is undue or unreasonable delay is a bar. And that is known. I don't have to say that I'm preaching to the converted, because this commission dealt with this in November. When the Semenya SC recusal application was raised here, the objection was undue delay. And this commission dealt with the matter, and at the end of its ruling, it said, well, the delay was undue, we deprecate that. That was it. In other words, even when the undue delay was found to exist, it was never seen by this commission to be a bar. So it cannot start now to be a bar. So much for the undue delay. Now, coming to the merits of the recusal grounds, assuming again that the affidavit is regarded as authorized. This is what I propose to do. That's the adjustment I was referring to save time, because the time is quite short. The main ground raised by former President Zuma is the one that relates to the alleged misconduct, bias in the form of giving advice to the evidence leader on how to succeed in the Semenya SC recusal application. The second ground is the ground which, again, for shorthand, I'll call the occupational history ground. And that's the ground that deals with the fact that the chairperson was previously employed by the Truth and Reconciliation Commission, its Amnesty Committee, and the NPA as the deputy NDPP. Now, then the third ground in the Zuma application is, of course, the utterances, attitude, hostility, vengefulness, hatefulness, all those that are pleaded in the founding affidavit associated with the detention without trial of former President Jacob Zuma. So this is how I propose to deal with the matters. And I want to be understood very clearly on this point. The third ground that I've mentioned, that's the Constitutional Court ground, is, if you like, is the alternative ground. If you go to the notice of motion, which you'll find, not our notice of application, which you'll find on page 2 of bundle A, you'll see that I think prayer 2 says is for the total recusal of the chairperson, and prayer 3 is for the partial recusal, if you like, only in respect of former President Zuma. So that ground is an alternative ground by any description, in the sense that it only talks to prayer 3. If it succeeds, put it this way, if only that ground succeeds, then obviously the chairperson would not recuse herself in total. She would recuse herself partially, quote unquote, in respect of him. So because there's no time, we can pack that ground. We're not abandoning it, but we're packing it because I want to highlight what I call the main ground. The second ground, other than the one that I'm going to deal with, is the one of the occupational history. Now that ground for us is, and one can argue these things in any sequence, I'm just trying to give a logical sequence. The second ground that I want to deal with is the occupational history ground. I'm not going to dwell much on that ground for two reasons. One, it is the main ground as far as in the Mbeki application. So I'm anticipating that my learned friends from President Mbeki will speak extensively on it. Two, our submissions have been extensively put in our heads and in the founding affidavit, and all of them must be taken as read. But three, most importantly, as a matter of law, our main ground, which I'm going to talk about now, is based on actual bias. And former President Mbeki's grounds are based on a reasonably apprehended bias. Now, as a matter of simple logic, if the ground on actual bias is upheld, then one doesn't have to bother about reasonably apprehended bias at all. I don't think I need to motivate that. So, as a result, for the reasons, 3 reasons that I've just mentioned, again, that second ground, as far as we're concerned, is persisted with, full blast. But for the purposes of oral argument, I will simply refer to it at the end, to the extent that I will still have time. Otherwise, we'll deal with it in reply. So everything we've said in the affidavits and the heads must be taken as read. So that then leaves me with the main ground raised by former President Zuma, which is the actual bias ground. That ground, as I say, is fatal to, if it's upheld, it's fatal to the entire case. Then there would be no need to deal with the other 2. Well, there might be a need to deal with them to the extent that the matter might go further than this. But for the purposes of the decision today, there'll be no need to deal with them. Why do I say that? One of the fallacies that appear from the papers of the evidence leaders is to conflate is an understatement, but to mix up the test. The test for bias, the test for reasonably apprehended bias must never be conflated with the test for actual bias. So, a simple example to demonstrate this is that we know that there's the so-called double reasonableness test, which comes from Sarfu, Sakau, and that line of cases. It should be obvious to anybody that that test only applies to reasonably apprehended bias, not to actual bias. Why? Because when you talk about double reasonableness, you are already talking about the reasonable person. In other words, you're talking about the objective test. But actual bias has got nothing to do with that. You can't say someone is actually biased because a reasonable person will think that they are biased. That's just terminological, not even an oxymoron, but it's senseless. So the court, or rather this forum, would then be spared if there is a finding of actual bias. It doesn't have to go into the double reasonableness test. Similarly, another test which they invoke is the presumption of impartiality. Again, the presumption of impartiality cannot apply in this situation, because here, although the chairperson who is being asked to be recused is judicially trained and held very high and esteemed offices in the judiciary, she is not being asked to be recused as a judicial officer, per se. She's being asked to recuse herself as a chairperson of an administrative body. So it cannot be that if, let's say, this was the recusal of Archbishop Tutu in the TRC, because he was not judicially trained, a separate test would have to be applied. But simply because the chairperson here happens to be someone who's judicially trained, then the test is different. That's also legal confusion. So, and let me put it very simply. A qua judge, is never appointed by the president in the way that a chairperson of an administrative tribunal is, number one. Number two, when a person is sitting as a chairperson of a tribunal, they are, as it is said in the heads of argument of the other side, they are, in a way, they are subservient to the person who appointed them. That's why it's said that they can only make recommendations. They can't act. The only person who can act is the president. Unlike a judge, when a judge issues an order, a judge issues an order. He or she doesn't depend on the whims of anybody to do so. So there's a vast difference between someone sitting as a judicial officer and somebody who happens to be a judge sitting as the head of an administrative body. With the greatest respect, a person sitting, chairing an administrative body appointed by the president is in no better position than an advisor to the president. In fact, that's what they do. They advise the president or make recommendations to him. They are in no better position to a director general who may make suggestions to the principal.
But the recommendation is based on finding. Now, where does the whim come in, or the influence? The chairperson would make a decision fact-based and not on the whim of the president who appointed.
Yes. No, Justice Khom, I think maybe either you didn't hear properly or I misspoke. If I did, I apologize. The whim is not at the level of the finding. You're quite right. The decision maker, any decision maker, whether it's Archbishop Tutu or whoever it is, makes a finding. That you can put aside. The whim comes like this, and this is trite as well. Once an administrative body makes recommendations to the president can literally take the thing and put it in the dustbin. Okay? That's where the whim is. When it's a court order, he can't do that. So that's the difference here. So that's, if I put it the way you're putting it, then I misspoke. Yeah. So the whim comes on the end of the implementation. And that is why, if you will remember that one of the defenses raised in this matter is exactly that this commission only makes recommendations, and it's correct. So that's where the whim is. Now, that, by the way, is another defense which has short legs, which doesn't carry any water, because it's related to the defense that says the commission is inquisitorial and not adversarial. That defense cannot go anywhere. It should die before even arrival. Because yes, of course, the commission itself, in terms of its terms of reference, carries its work inquisitorially. But this is a sui generis application, the recusal application, as was the Semenya recusal application for that matter. And the recusal application is clearly adversarial. So the fact that the commission itself might be inquisitorial is neither here nor there. And to the extent that it is adversarial, it is improper conduct for the chairperson to give advice to one of the adversaries. Plain and simple. If the matter is adversarial, as it obviously is, then the rule that applies is the one that was enunciated in the SCA in S versus Roberts, 1999 4 SA 915 SCA at paragraph 23, that you'll find in the preamble to our heads. And it says as follows, it's very simple. That justice publicly be seen to be done necessitates as an elementary requirement to avoid the appearance that justice is being administered in secret. that the presiding judicial officer should have no communication whatever with either party except in the presence of the other. Now, this is what we call an a fortiori case. So even when that person who's sitting there is chairing an administrative body or even a DC, for that matter, at work, that they can advise the employer or the employee in that particular adversarial setting is plainly, one doesn't have to be a lawyer to understand that there's something rotten and wrong with that. So this principle is quite clear.
But you did not bring out the content of the advice. It's just advice in vacuum, the expression advice. The content of the advice,
yeah.
The text of the advice.
Yeah, the content of the, yes, that's one of the defenses. That's wrong, plainly wrong. Because if you go to paragraph 38 of the founding affidavit, and you'll find that in bundle A, sorry. And maybe let me start by explaining the following. The content of the advice, Justice Homer, is specified in the paragraph 38, 39, and 40, which I'm going to read out to you now. Well, one of the things we're told is that we don't say the place, the time, and what the issue you are raising, the content. It's not true. As far as the time is concerned, this is what 38 says. In the build-up to the hearing of the Seminar recusal application, so that's the timing. It was in the, it's not the date, but we situate when it was. Justice Khampepe, as a member of the judiciary and as a decision maker who would ultimately make a final ruling, conducted herself improperly and exhibited actual bias in favor of the non-recusal of Advocate Zuma. And here's the important part. A good example, or shall we say evidence of this, is that Justice Khampepe, without the knowledge of the applicants, privately and secretly gave advice to Advocate Seminya SC on certain key weaknesses in his case, that's the content of the advice, and even advised him on what to look out for and what to convey to his legal representative, Advocate Vasoni SC, in order to succeed in the recusal. That's the content of the advice. This is a case of plain and gross misconduct, irrespective of the merits or demerits of the Semenya recusal application. Then we say at 40, purely in order not to jeopardize ongoing investigation into this serious conduct, which poses a threat to democracy, I deliberately and consciously refrain at this stage from revealing the complete, underline complete, evidence available to me. If the accusation is denied, then I will be left with no option but to resort to alternative procedural mechanisms in order to secure or provide the evidence. I trust that this will not be necessary. So this is what happens here. Surely, it should be sufficient. If you allege that advice was given, one, to advise the person on how to succeed, and secondly, to advise him on what to look out for to convey to his legal representative, Advocate Vasoni. Those are specific allegations. How can it be said that the content is not given? Whether that at that point the advice was change this paragraph or that paragraph or look up this case or that case is neither here nor there. The misconduct is in the giving of the advice without the knowledge of the other side. That's where Roberts puts emphasis. There's nowhere in what I read from Roberts that says the judicial adversarial, it says should have no communication whatever, right? So whether the communication is X, Y, or Z, doesn't matter. It should have no communication whatever with either party except in the presence of the other. That's the gist of the... It's not even this red herring thing about whether it was secret or whether it was done, whatever. The point is the non-disclosure to the other side of such communication. It's not done. Everybody knows that. Again, one doesn't need to have an LLB to know that a decision maker cannot advise one of the adversaries about anything. Doesn't matter whether it's about a big thing or a small thing or a medium thing. So that's the gist of the attack. And to the extent, to anticipate what my learned friends will say on this, to the extent that, yes, for reasons that I explained here and in the replying affidavit, some of the evidence, because of what is put in the as ongoing investigations, because some of that evidence might not be complete, that's why I put the emphasis on the word complete. Well, so be it. It's not presented. But that's not the test of how you test evidence. There's something in law of evidence called the sufficiency of evidence or the cogency of evidence. So to make a blatant example, if I have evidence that somebody has stolen bread from a store, I can, at that stage, lay a charge against them for that. The fact that it might turn out later that they also stole eggs and they also stole milk and what have you, well, the point is the evidence that's presented at that time sufficient at that time to establish that which I'm accusing the person of? And in our respectful submission, this evidence that is here is sufficient. We agree with our learned friends. They say in the answering affidavit, well, if you don't give us that further evidence, then your application must be dealt with on the basis of the allegations in the founding affidavit. We concede that. We can't expect the tribunal to make a finding with some withheld evidence. But the point is that on the evidence that has been presented in the founding affidavit, there is sufficient for allege, or not allege, to establish, as a matter of fact, that the rule in S versus Roberts was breached. And that's enough.
Yes, you've made your point.
Yes, thank you, Justice Hong. Now, if that, assume now, I mean, there might be engagements on all of this, but for now, I beg the panel to assume that we're correct on those facts. In fact, the reason why you must assume that we're correct is because there is nowhere in these papers where the giving of the advice, which is the gist, is denied. Nowhere. We're given a diversionary story about the only defense actually is that, no, the evidence leaders and the commissioners have frequent interactions. The answer is, so what? Who has disputed that evidence leaders and commissioners have frequent interactions? So it's not the interaction per se, it's the fact that this was an improper communication. Nobody in their right mind will say evidence leaders must not talk to commissioners about the weather or about the matters to do with the terms of reference. But once there is a specific recusal application for a particular purpose, and the commission and the chairperson sends an email that says, please watch out for paragraph 45 or this and that, which is also there in the affidavit, or do this research or whatever, then that's just wrong. I mean, honestly, I shouldn't be standing here explaining that is an affront to the Constitution and an affront to the oath of office to the extent that it is relevant. of any office for that matter. Sorry. Right. Now, the point is this. In the absence, and my learned friends, again, to their credit, they say in paragraph 6, a proper consideration of the affidavits of their heads that have been filed suggests that, save for the allegations made by former President Zuma of improper interactions, and I'll come to that, and Siminya SC, for the most part, the applicable facts are not, in essence, in dispute. That is true, except that the exception that they carve out also doesn't apply. What has been pleaded here, in plain and simple terms, Civil Procedure 101, is what is called confession and avoidance. Now, confession and avoidance means this. You say, yes, the advice was given, or I don't dispute that the advice was given. But, as they say, there's nothing wrong with it because commissioners speak to evidence leaders all the time. But that's what is called a non sequitur, because the fact that evidence leaders, we all know, my learned friend Mr. Siminya and I have been in many commissions together. We know that happens. But that's not the point. That's diversion. It's called a straw man defense. You create your own case and then you fight that case. That's their case. Our case is simple. It's got nothing to do with the frequency of interactions or non-frequency of interactions. It is that in this particular interaction was improper, illegal, and against anything that any decision maker should do. Now,
if I may, you're eating into your time.
Pardon?
I say you have eaten into your time. You have eaten into your 30 minutes. Carry on.
Okay. Thank you.
It's just a friendly reminder.
Yes, no, thank you. I take it as such. So the point really being made, and I have to make this point, this is not a complaint about, at least not yet, about misconduct in the JSC sense of the word. Those proceedings, if they happen, and former President Zuma has said that he will institute them, will take their own course. Here, we're only dealing with a narrow issue of whether, assuming that the facts, the confession and avoidance is held to be admitted, because that's really what it is. Okay, let me go to basics. And this will be just the point preceding my last point, Justice Kong.
Mr. Mpofu?
Yes.
Your time has expired.
And that's what Justice Kong. Pardon? Wrap up, yes. Okay, thank you, Justice Khampepe. Now, I'm saying, in wrapping up, let me say this, because it's very important that these pleadings must be read for what they are. Confession and avoidance is described as follows. You say, I admit your facts, but even based on those facts, I'm giving you facts that countervail those facts, and therefore a different legal conclusion should be reached. You'll find that in Erasmus, I think it's, yeah, you'll find it in Erasmus. I don't have time to read it out now, but you'll find it at D1-22.8 under confession and avoidance. So you can't have, if you have a confession and avoidance, but you don't put countervailing facts, because the onus shifts in a confession and avoidance. Once you admit, you then have the onus as the admitter to put those countervailing facts. That's known as the Mabaso principle. If you fail to do so, then all we're left is the confession without an avoidance. So the confession is otherwise known as an admission. So those facts are admitted. Secondly, and lastly, and I'm indebted for the indulgence. this principle of failing to deal with such a serious accusation has been dealt with in our courts many, many times. It has been said in old cases, there's a case, just the name just escapes me now, a case, I think it was in the 20s or 30s, where it was found that if somebody makes a serious allegation against you and then you do nothing, you just look down, that is as good as an admission. That has been qualified by the SCA in subsequent cases. But the point I'm making is simply this. Faced with such serious accusations as I've read out, the absence of a denial or any explanation surely means that those facts are common cause. And none other than Justice Khampepe made that point in the case of Public Protector versus South African Reserve Bank, or the so-called CX case. She said at paragraph 190, the Public Protector's failure to deal pertinently and responsibly with the serious accusations made against her impartiality in light of these meetings that she had allegedly had with the President, meant that the High Court was left with only the handwritten notes as evidence of what was discussed at the meeting and no countervailing account from the Public Protector. This led the High Court to conclude that, quote, the question remains unanswered as to why the Public Protector acted in such a secretive manner, and she does not give an explanation for doing so. That is good law, and to the extent that it is good law and it is authority of the Constitutional Court, it must apply here. Because Justice Khampepe was quite correct. When somebody faces a serious accusation against her impartiality, the least you can expect is that they will give an explanation. And if absent that explanation, with the kind of wishy-washy version that we've been given in the answering affidavit, so-called, then the accusation remains unanswered. And if it remains unanswered, the chairperson must recuse herself on that basis alone. Firstly, for giving the advice, for having the communication undisclosed, and for having it in the absence of the other party in these kinds of proceedings. And for the last parting shot is that in the Pinochet case, the famous Pinochet case, the issue of non-disclosure, which really is the nub of this, not the secretive what. The issue of non-disclosure was held in that case as decisive. And I am aware, before somebody reminds me, that that case was decided on the basis of a reasonable apprehension of bias. But everyone knows that actual bias, the alternative to actual bias, if the tribunal doesn't find actual bias, then of course the reasonable apprehension, such as was the case in Pinochet, is sufficient. Because I've run out of time, I will, as I said, defer on the question of the occupational history. I will defer on the question of the occupational history to the Mbeki team, but as I say, I stand by whatever is in our papers so that I'm not deprived of dealing with that matter in reply, should it be necessary. I'm indebted for this.
There's just one aspect that
yes.
My learned colleague would like to deal with you.
Yes.
Thank you.
The first one is just for my own understanding. In the paragraph 15 of Mr. Zuma's affidavit, he refers...
Founding. The founding.
I can just, you can just listen, but it's paragraph 15. You refer to the commission that had to locate the DSO, the Scorpions, chaired by Judge Khampepe as the Commission of Inquiry. But at 17, the commission chaired by Chief Justice Raymond Zondo, you say the so-called commission I don't know why the distinction and what does that imply, so-called commission?
No. Well, firstly, I don't know if you are reading the same paragraph 17. There's no so-called commission there. It says, I was required to appear before the so-called Zondo Commission. So the so-called is not about the commission. It's about the fact that it's colloquially known as the Zondo Commission. But the name of the commission is, it's called the Commission into Allegations of State Capture, Corruption and Fraud in the Public Sector, including organs of state. And everyone, to avoid that long thing, called it the Zondo Commission. So that's why it's called the so-called Zondo Commission. I don't know.
But the other one was not so.
It was.
Okay, but you don't see that. But let's go to paragraph 52 of the statement. Can you just read it? Because my understanding seems to be that if Justice Khampepe does not recuse herself, or perhaps if the finding is that she does not recuse herself, then Mr. Zuma is out of here, is not participating. Can you just read that and speak to it briefly?
Well, okay. Before I even read it, that conclusion is not correct. But let's read it. It says, last but not least, the previous conduct of the chairperson in relation to my controversial detention without trial and the subsequent negative public commentary make it untenable for me to comply with the request to participate in the present commission, as set out in Rule 3.3 notice sent to me by the commission, and in any process which is tainted by her demonstrable and or reasonably perceived bias. For ease of reference, refer to the notice. No, you're reading that paragraph wrong. That paragraph is very simply says that and it goes to what I call the alternative, the narrow recusal, which would pertain only to former President Zuma, and has nothing to do with former President Mbeki. All that paragraph says is that it motivates why it is, it's the same as saying, if there's a judge who took a bribe, and I'm aware that the judge took a bribe, it's untenable for me to be expected to carry on in front of that judge. I mean, it's that simple. And that's all he's saying. He's saying, given what he calls, tainted by demonstrable and or reasonably perceived bias, then it would be untenable. Now, of course, that does not suggest anything about out of here. All it suggests, in fact, let me put it plainly, is that should this commission find that this ground, serious as it is not sufficient, and the chairperson should nevertheless continue having given advice to advocate, to my learned friend, Advocate Siminya SC, then former President Zuma will exercise his options which are provided in the Constitution. One of them he has already mentioned, that he's going to approach the Judicial Service Commission. The other one, which is obvious, is that he could approach the court. So that's what that paragraph is meant to convey. Nothing more, nothing less. And as I say, any one of us, any human being, would find it untenable to appear under such circumstances. If I may just say one word about the Kalata Group. Of course, our papers cover and our heads also cover the statements made in the Kalata Group. But for the record, it must be said here and now, plainly, that nothing in this application is meant to take anything away from the validity and the concerns of the Kalata Group, or to divert the serious work of prosecuting murderers who are responsible for vile apartheid atrocities. But the fact, if that process, important as it is for this country, is done before a tainted commission, then that is what will delay for another 10, 20 years the process which is so important for this country. So nobody must ever walk away from here. They must disabuse their minds from one, that there's a need, or rather a desire to delay this process, other than to cure its imperfections and its taint of bias. Thank you.
Thank you, Mr. Improper.
Sorry.
Maybe I would probably not expect the chair to say that, but she could if she wished. There's some strong language used by Mr. Zuma that the chair harbors deep-seated hatred and animosity
Yes.
towards him.
Yes.
And another strong word is that she acted with malice. All these words are
Yes.
very strong, and it seems it emanates from the judgments that she penned. As I look through the papers, at least speaking for myself, that is my impression.
Yes. Sorry.
The need for those choice of words, if the chair acted or penned a judgment, a majority judgment, is there justification for that?
Look, the Justice Homo, I don't know. I'm not the one who was sitting in a cell detained without trial. So if...
I'm not talking about that.
But
I'm not talking about
No, but that's what this point is about. This point, I thought we are dealing with the third leg. That's what it is about. The point about the judgments in the Constitutional Court have to do with the detention without trial, unless maybe I'm on another page.
Carry on.
Yes. So, being not the person on whom the shoe pinched, I cannot speak for the deponent use of...
Of course you can speak.
Well, if I can just
because
finish.
you are counsel, from 1958 in the Matonsi case, you leadership, and if there are things that you know cannot be backed up, even in the rules, LPC rules, you're not supposed to press that aspect.
Yeah. No, that of course is true. But if you allow me to finish, then I will develop the point. Firstly, that rule applies to all of us. So, Mr. Smenya's affidavit says the application for the recusal of the chairperson is spurious, vexatious, scurrilous, and even malevolent. That's equally strong language to use the adjective that you used. Now, the point of the matter is that we should assume again that when Mr. Semenya makes this, he's not making them for himself. Those are the views of the chairperson, presumably. And therefore, the strong language used on both sides must be looked at in its proper context. What President Zuma says, Justice Homo, is that he doesn't just say you must read the judgments, as you say. He says the tone, and the posture, which was adopted in sending him to jail without a trial, the first of its kind in the new South African.
Without a trial or hearing?
Without a trial. Trial. Section 35(3), right to a fair trial. That right to a fair trial, which is the right to say I'm guilty or not guilty, the right to appeal, or the right to mitigate. Section 35(3) of the Constitution, all those rights to a fair trial were negated. So that's a fact. Now, the number one. Number two, it says on top of the tone, something which is, I don't want to suggest the evidence, any ill will on the part of the evidence leaders. But you must read their answering affidavit and read their heads.
Yeah, but Mr. Mpofu, you are standing there. The evidence leaders have not come yet. We are on that aspect.
Yes. So I have not even made the point I'm going to make. I mustn't make the point?
Maybe no.
Thank you. No, the evidence leader, the point I was making
At
is
this
that,
point.
yes, the evidence leaders have not said a word, not one word, breathed one word about the allegation in the founding affidavit that Justice Khampepe conducted a publicity campaign on why former President Zuma was convicted without trial. She went and had an interview with Olim Gambi of Newsroom Africa, and another one with a Karen Mon of News 24. That is not done, right? So a person who has been subjected to all those things, detention without trial, an uncharacteristic publicity campaign about a case, and sorry, Justice Home. Just 1 second, please. All I'm saying is that it should be understandable. It might not. The tribunal will take its own view that why someone would use such language, which, in my respectful submission, is probably more measured than the true feelings of former President Zuma. But Article 13 of the Judicial Code states that a judge must, Article 11, save in the discharge of judicial office, a judge must not comment publicly on the merits of any case pending before or determined by that judge or any other court. Not enter into a public debate. A judge must not enter into public debate about a case irrespective of criticism leveled against the judge, the judgment, or any other aspect of the case. Both of those rules were breached in a superlative way when those interviews were done. So how would you feel? And I'm not asking you to answer, it's a rhetorical question, Justice Home. How would one feel that somebody not only takes you to jail without trial, but goes on forever justifying it in the public domain in breach of the judicial code of practice? Would you give them a hug? No. You will feel strongly about it, and if those strong feelings are reflected in the affidavit of former President Jacob Zuma, then so be it.
Yes, you have made your point. Thank you.
I'm indebted to you.
Thank you. Ms. Muvangwa.
Yes, thank you. As it pleases the Commission.
So I don't know whether we should not anticipate the tea break so that we don't interrupt the submissions of my learned colleague.
We shall take Ms. Muvangwa's submissions. Ms. Muvangwa.
As it pleases the Commission, Madam Chair. Our client's case is based on an apprehension of bias. It is important to make that clear up front. Our client seeks the recusal of the Commission's chairperson on 2 grounds. The first is her prior institutional role in the TRC and the NPA, and the second is her handling of procedural complaints in this commission that related to the lead evidence leader's conduct. While these grounds are standalone and independent, we also argue that they're mutually reinforcing and must be viewed cumulatively in the sense that they create an apprehension of bias. I'll provide a roadmap so that the commission might find it easier to follow where I'm going. But before I do that, I want to just state for the record that we do make common cause with the submissions made by my learned friend, Mr. Mpofu, relating to the reservations that my clients have about Mr. Semenya SC's deposing to an affidavit on behalf of the commission. I do not wish to traverse that because he's already done that, and in the interest of time, I won't. Safe to say, though, that the allegations in the founding affidavit must be seen as accepted because there is no counter evidence directly from the chairperson. On the roadmap, though, we propose to present our case as follows. We provide first the legal framework. We accept that it is not disputed, but it frames our argument, so it is convenient to do so. The second thing we do is to address the first ground of recusal, which is the institutional bias. The third thing we do is to address the second ground of refusal, which concerns the handling of complaints. The fourth is we explain why we say that even though the grounds remain independent, viewed cumulatively, they create a reasonable apprehension of bias. And it is important that they are also viewed together. And finally, we deal with delay. On the legal framework, the point of departure for present purposes is section 165(2) of the Constitution, which requires judicial and quasi-judicial power to be exercised impartially and without fear, favor, or prejudice. We submit that those provisions apply with equal force to judicial commissions of inquiry exercising public power. This is so because judicial commissions of inquiry derive their authority from the Constitution and exercise public power. The Constitution subjects them to constitutional constraints, which include principles of legality and fairness. There is authority for the submissions, commissioners, and it lies in Corruption Watch, citation 2020, brackets 2, close bracket, SA 165. The court said in paragraph 51 that in the exercise of its functions, the commission had to act within the confines of legality. It could not, for example, perform its task by demonstrating bias, breaching fundamental principles of fairness, or commit significant errors of law, such as refusing to admit evidence or on manifestly incorrect legal grounds. So the point made there is the applicability of the principles to judicial commissions of inquiry. Now, it is common cause that the chairperson of this commission is a retired judge of the highest court in the land. She took an oath of office, which requires her to administer justice to all persons alike, without fear, favor, or prejudice, and in accordance with the Constitution and the law. What that does is it imposes a presumption on impartiality on judicial officers, and Sakao, which we refer to in Heads of Argument at Para 12, gives us that principle. However, the presumption may be dislodged where there is cogent evidence that demonstrates a reasonable apprehension of bias. Masuku, referred to in paragraph 13 of our Heads of Argument, gives us that principle. On the test for bias, apprehension of bias, Safu gives us the principle. It is this: whether a reasonable, objective, and informed person would, on the correct facts, reasonably apprehend that the judicial officer will not bring an impartial mind to bear on the matter. So there is a double requirement of reasonableness here. The first is that the apprehension itself must be reasonable. And the second is that it must be held by a reasonable person. So the suspension of bias must be based on reasonable grounds and not on speculation or unfounded allegations, and that's very important to bear in mind. I move on now to having laid the framework thus to the first ground of recusal, which concerns the chairperson's role in the TRC and the NPA. I must say we deal with this in paragraphs 24 to 27 of our heads of argument because I'm flying through it because of time. But I must commence with the principle. The legal principle is to know what makes, well, perhaps institutional bias of an institutional nature would occur where prior institutional involvement of the presiding officer creates a perception of bias. But that does not, just because the chairperson was in the TRC or the NPA, does not without more give rise to an apprehension of bias. We probably all know the principle. What must be met as a matter of legal principle is that there must be a connection between that role and the subject matter, in this case of this commission. The Constitutional Court in Burnett lays the principle that a reasonable apprehension of bias may arise where a judicial officer in a former institutional capacity either advised on, participated in, or acquired personal knowledge relevant to the issues now before the tribunal, in this case, this commission. Sarfu says the same thing. A reasonable apprehension of bias cannot be based upon political associations or activities of judges prior to their appointment to the bench, unless the subject matter of the litigation in question arises from such association or activities. So, commissioners, those principles frame the inquiry into the first ground of recusal. The contention by the Kalata group and the evidence leaders and the commission turns on two things as we understand it. The one is the date of the chairperson's involvement in the TRC and the NPA, and the second is the subject matter of her involvement in those institutions. Now, the argument on the subject matter is that the commission's mandate here is limited to investigating and is it limited to the investigation, to the frustration of investigation and prosecution of what we know to be TRC cases. So what was the question really is whether and to what extent there was political interference in the prosecution of the TRC cases. And that was not the work of the TRC Amnesty Committee and the NPA. That's what the respondents argue, not me. So on that basis, they say, the chairperson had no involvement with the matters now under inquiry during her tenure at those institutions. On the contention about the commission, the temporal confinement of this commission, the argument is that in terms of the terms of reference, the commission is to inquire on political interference commencing in the period 2003 and not before, and that the chairperson was involved in those institutions up until 2001. Now, commissioners, with respect to my learned friends for the respondents, that argument is unhelpful. The temporal conscription of the commission is artificial and unhelpful, and we say so for at least two reasons. The first is that the Kalata group itself accepts that limiting the inquiry to events from 2003 onwards is irrational. And this concession, and they say they agree with President Beki and the ministers that it is irrational. And this is actually consistent with the Kalata group's papers in the High Court, where they allege that political influence originated in discussions between former Defense Force and Police Force generals and ANC officials, and that those commenced in 1998. It would be recalled that from our papers that that was a period that Justice Khampepe was in the TRC and the NPA. The second, though, is that those same allegations are repeated in the Rule 3.3 notices that at least President Beki got, former President Beki got, from this commission in September. In other words, there was a copy and paste from the Talata Group's papers in the High Court and into the notice that he got. And that goes as far back as 1998 and does not begin in 2003. And that's why we say that the temporal circumscription of the commission is quite frankly unhelpful. This is also reinforced by the Talata Group's own answering affidavit. There, they advance a series of conclusions that fall directly within the commission's mandate and must be investigated. They say that during 1998 and 1999, the NPA was prepared to investigate and prosecute TRC cases until 2003. In other words, before 2003, the NPA pursued serious apartheid-era prosecutions without hindrance. They then say that active interventions, which suggest to us at least that there may have been inactive interventions, which are unclear, to frustrate such prosecutions only began in 2003. After Justice Khampepe had left the NPA. So that's a proposition that ought to be investigated. Now, what then of the role of Justice Khampepe in the TRC? And we again deal with this in paragraph 57 to 58 of our heads of argument. Our case is this. Justice Khampepe was no peripheral or administrative person within the TRC. She was appointed as a commissioner at the heart of that process. And in that capacity, she participated in the formulation of the TRC's findings and recommendations, including evaluative judgments about responsibilities for gross human rights violations. She assessed, do you qualify, you don't qualify. She later served as a member of the Amnesty Committee in 1996 to 2001, where she assessed and determined amnesty applications brought by perpetrators of apartheid-era crimes. Where amnesty was refused, the TRC made recommendations to the NPA to pursue prosecutions. Those functions form the institutional and decisional foundation upon which the present commission's mandate rests. It is the bedrock of why we're all here. So, this commission is now tasked with examining whether, why, and how prosecutions flowing from the TRC process were frustrated, delayed, or obstructed. The inquiry necessarily revisits the effectiveness, sequencing, and implementation of the TRC's prosecutorial recommendations. It's the Continuum.
So, Ms. Muvangwa, when the amnesty applications were being considered by the Amnesty Committee, was the issue of a failure to prosecute considered in those decisions?
It was never the mandate of the TRC committee, and it could never have been, it would be illogical, for them to inquire on whether or not there is a failure to prosecute, because that comes later.
So help me determine the link.
Yes. So what we submit, though, is that it starts with, remember the principle is, bias could be apprehended because a decision maker who was involved in that process could have been incentivized to defend the integrity of their processes. The TRC recommended prosecutions. The Continuum follows. And down the line, we are told that there was frustration, and the very same person who recommended prosecutions has to inquire one way or the other about the so-called political interferences. It is that continuum that gives rise to an apprehension of bias.
So you see it as a continuum rather than a direct link?
It is. It is definitely a continuum. That's why we argue, Commissioner Gabriel, that this is the bedrock of why we are here. We cannot divorce the two. It will also be recalled, and this is in our papers, I apologize that I didn't make a note of it immediately for oral argument, that part of the people who appeared before the TRC commission was the so-called ANC 37. And what is alleged by the Kalata group is that the political interference came about because the ANC 37 did not want to be prosecuted. Those are the allegations. That is the very thing that this commission has to determine, and that comes from there. So all of this to say that, appraised with these facts, a reasonable person would apprehend that a person who participated in shaping the TRC's evaluative conclusions and prosecutorial pathways may be perceived as being placed in the position of indirectly assessing the success, failure, or derailment, this is what I said earlier, of the process in which she played a formative role. So it is that institutional proximity.
I have another question. On the question of delay, when is it that President Mbeki knew about all of this that you've just spoken to us about?
Would it be convenient if I deal with all of that when I address the question of delay?
Yes, okay.
Thank you. And I won't run away from it, I'll come to it. On the role in the NPA though, and this we deal with in paragraphs 59 to 61 of our heads of argument, the case is this. It is not disputed that Justice Khampepe was appointed as the Deputy NDPP in September 1998 up until December 1999. And at a time when the HRIU was operational within the NPA, the mandate of the HRIU was not peripheral to the subject matter of this commission's mandate. The HRI, I'm going to say the Human Rights Unit, was tasked with reviewing TRC amnesty records, investigating apartheid-era human rights violations, and making recommendations on the prosecution of TRC cases. Again, that continuum comes back. So in other words, the Human Rights Unit lay at the very heart of the prosecutorial machinery that this commission is now required to scrutinize. Now, commissioners, the Kalata Group tells us that the chairperson of this commission played a role in the work of the Human Rights Unit, including advising the NDPP on the approach to the TRC cases. This assertion was not disputed on the papers. What is more is that at least my client sought clarity both in the founding affidavit as well as in the replying affidavit on the specific nature of Justice Khampepe's involvement in the Human Rights Unit, and that clarity never came. So in the circumstances, therefore, a reasonable objective observer would note that Justice Khampepe occupied one of the most senior prosecutorial offices in the country at the time when the NPA was actively shaping its approach to TRC-related prosecutions. Now that's direct. On the issue of the fact that the chairperson's role in the Human Rights Unit was not clarified, notwithstanding requests for clarity, potential trouble could also be that once Justice Khampepe, because it lies within her providence, personal knowledge, once clarify by. Okay, so let me just go back.
By whom?
Yes, could I go back just to
yes.
Make sure it's logical, the submission. So the Kalata Group told us that Justice Khampepe was involved in the Human Rights Unit. We know that the Human Rights Unit advised on policy for effectively prosecuting, related to the prosecution of TRC cases. That's the first block. once we were told this, my client sought clarity on the particular nature of Justice Khampepe's involvement in the Human Rights Unit. This he does in the
I
founding.
hear you.
I'll get to it, Commissioner Khom.
Yes.
This is in the founding affidavit. One would have expected one of two things to have happened by way of clarification. One would have expected that the chairperson herself would have clarified. One would have expected my learned friend, Mr. Semenya, deposes to an affidavit purportedly on behalf of the commission. One would have expected clarity to emerge from that, accompanied by, at the very least, a confirmation from Justice Khampepe. One would have expected the Talata group itself to provide clarity on what the exact nature of her involvement was.
Yes.
All right. Now, if we could go to the second ground of recusal. That ground has two prongs to it. The first is the chairperson approved an irregular arrangement between my learned friends, Mr. Semenya and Mr. Vani, concerning the leading of witnesses in her ruling of 2 December 2025. That's the first part of the first prong. The second part of the first prong is that thereafter, she summarily refused to furnish reasons for that decision, despite detailed objections raised by various parties, including the applicants.
But there I must come in. Where is the list?
I beg your pardon?
Where is the list? Where is the dispute? Because there is a consensus, there's an agreement on that aspect. There is no longer a list. It doesn't exist, it's not alive.
Okay. What I have planned to do, which I will get to immediately, is set out a chronology to demonstrate that presented with these facts, a reasonable person would apprehend that the chairperson is predisposed to I beg your pardon, a reasonable person would apprehend that the chairperson is inclined to preserve Advocate Semenya's participation, notwithstanding clear procedural irregularities and attendant unfairness concerns. Remember, the test is about fairness. Perception of bias is about fairness. Now, if I could please just go to the chronology, to the sequence of events. This is not an evaluation, it's seeing what is presented objectively. The chronology with respect to the first prong of the second ground is this. On the 18th of September, there was a letter written by Weber Wenzel. We know that Weber Wenzel is the attorneys of record for the Kalate Group, advising the chair of a potential conflict of interest regarding Advocate Semenya SC and requesting that Advocate Semenya SC not be involved in any deliberations or leading or cross-examination of witnesses in relation to the amendments of the prosecution policy. That's what the letter does. I'm just now telling the narrative of the facts. On the 19th of September, there was a letter from the commission's chair to Weber Wenzel, which assured the parties that Advocate Semenya SC would not engage in deliberations regarding the prosecution policy, and that another member of the evidence team would do that.
You are building to a certain point. But maybe if you can make that point, because I'm not quite sure whether there is a dispute because there is an agreement.
No, Commissioner Khomo.
You're building towards that point, but where does it lead us to?
Could we go back to the test? The test is whether a reasonable person armed with a particular set of facts would apprehend bias The submission is that a reasonable person, let me finish quickly, I'll just tell you one more thing of what happened after that.
Okay.
So
Well,
justice,
maybe
yes,
let me leave you.
it's going to take 2 seconds, maybe not.
Yes, carry on.
So what happened after that? So there's a complaint by the Kalata group. The justice says, I hear you, I direct that Advocate Semenya SC will have nothing to do with the prosecution policy and that somebody else is going to do that, okay? What happens on the 13th of November though? Evidence leaders led by Advocate Semenya SC, what do? They interview Mr. Silas Ramaite. And that interview canvassed the very thing that the chairperson directed against. What happened what was the consequence? None. And that's the complaint. So armed with those set of facts, a reasonable person would apprehend bias.
And would that reasonable person also consider that that preliminary direction was withdrawn?
Rebecca, please, can I say that again?
That preliminary direction was pronounced pro non scripto.
At that stage, it wasn't.
So my question to you is, would a reasonable person choose the facts upon which to rely or consider the totality of facts?
Yes, they would, except that direction was never withdrawn. It is common cause that the NPA filed a supplementary affidavit complaining about the fact, and this was before the recusal application was determined. So at that stage, the directive remained in place. So when he contravenes, the point is this though, when that directive is contravened, it was still in place. It was still in place. So Commissioner Homo, that's the apprehension of bias on that score. The second prong of the second ground is that the chairperson effectively sanctioned Advocate Semenya's breach. Sorry, I already dealt with that, sorry. I want to go back to
We want you to go ahead, ma'am.
yes, I do, but I was dislocated, so I must now regain balance, please. The second aspect of the second ground concerns an agreement between, again, Advocate Semenya SC and my learned friend, Mr. Vani. On the 29th of September, a private arrangement was entered into between the two advocates, in terms of which Mr. Vani would lead the evidence of the Kalata witnesses instead of the Commission's appointed evidence leaders. This was only disclosed to everybody else on the 27th of October here. And the parties objected to the fact that there was this private arrangement. Parties were then ordered to file formal objections by the 5th of November and submissions by the 7th of November. This was duly done. On the 2nd of December, Justice Khampepe handed down a ruling on the objections and endorsed the private arrangement between Advocate Semenya SC and Advocate Vani and provided no reasons. In anticipation, Commissioner Gabriel, so what? Wherein lies the sting? What gives rise to an apprehension of bias? Two things. The first is there was no investigation of the private arrangement whatsoever. It was just sanctioned. There were no reasons provided, and reasons were refused, notwithstanding their request. Never mind that there were detailed objections. A reasonable observer would, at the very least, in light of the totality of the facts, including the detailed objections, have expected reasons.
Right, and that totality of facts would include the fact that President Mbeki's legal team was part of and formulated a consent order that was brought to Justice Khampepe.
Yes, but remember, the consent order was not to permit the private leading of evidence. The consent order was to file, that's why objections were filed. You see, so the totality of evidence also includes the very fact of detailed objections. The totality of facts also includes the starting point of that private arrangement, which was 29 September. It must be recalled that the Kalata group is one of the people before the commission in the same fashion as my clients are. So the idea that there is private arrangements being made and there is no investigation gives reasonable apprehension of bias to a reasonable bystander.
Ms. Muvangwa,
Yes, Justice.
I must alert you that your time
Time.
has expired.
Okay, I will move
Ms.
along.
Mopangwa, could you please specifically, for my purposes,
Yes.
deal with when President Mbeki and/or his legal team became aware of the institutional history of Justice Khampepe?
Okay, that goes to delay. Let me deal with it immediately. On the question of delay, it has always been known to my clients that Justice Khampepe was involved in the TRC and the NPA. But it was never open to my clients to bring my learned friends, the respondents say that my clients ought to have brought a recusal application in May 2025 at the earliest. We argue that it would never have been open to my clients to do such a thing for a couple of reasons. The first is that it is common cause that my clients sought to intervene in the proceedings before the High Court. Their applications was dismissed on the basis that another court had already determined.
Yes, we're aware of the history.
I beg your pardon?
We're aware of that history and that order.
Sure. So fast forward then to the issue of delay. Delay must only be taken into account from September 2025 when my clients are drawn into the commission through the Rule 3.3 notices. It is only at that point that it would be open for them to seek the recusal of Justice Khampepe. So where am I going with this? The test first of all, delay is not itself dispositive of an application. The overriding factor is interest of justice. The legal principle requires that an application for a recusal be brought as soon as reasonably possible. We argue that it was brought in as soon as reasonably possible, and I will tell you why. I will call into aid some legal principles. Case law has said that once you consider an application for a recusal, you must factor in a number of things. One is the reasons for the recusal. The other is the extent of the delay. And the third, and this is not a closed list, interest of justice doesn't have a closed list, factual inquiry, is where the proceedings are at that point in time. It might be recalled, because we deal with this in our heads of argument, that in Bennett, the court rejected an application for recusal, which was brought 2 years later. Why was it rejected? Because by then, witnesses were called, evidence was led, people were cross-examined, etc., and the trial had been going on for 4 years. So on that basis, it was not in the interest of justice to entertain the recusal application. In this case, though, having set out the grounds of recusal, the contrast here is that the commission has not commenced with its substantive work. No evidence was led. In fact, the commission has not yet, the evidence leaders have not yet provided my clients at least with witness statements. So substantive work has not been commenced at all. And the prejudice would arise to my clients would be severe, because any subsequent proceedings that they will be participating in would be a nullity down the line if it is found that Justice Khampepe ought to have recused herself. And that would also lead to wasteful expenditure, if it is so that the commission starts its substantive work, notwithstanding the grounds of recusal, simply because my clients ought to have, simply because the commission may form the view that my clients ought to have brought this application on 25 September when they received the Rule 3.3 notice, without more. Does that answer the question? Okay. I really want to go back
I
to...
may be conflating the statements by former President Zuma and former President Mbeki, but does your client not say, no, I waited to see the outcome of the Semenya recusal application, and I tried to draw the link.
No, my client doesn't say that.
I didn't say that.
No. I think that, Commissioner Khomo, you read from paragraph 64 of my client's founding affidavit, and that concerns that's to do with the condonation for the late filing of this recusal application, because
You should just have said you conflated. Okay.
I wanted to be polite, you see.
Ms. Mufangwa, I must remind you that you are running on more than extra time.
Yes, just literally 1 minute. I just want to draw the commissioner's attention to an argument that I don't want to seem to have abandoned, which is that it is important that these grounds, although stand alone in and of themselves, must be viewed cumulatively, and we deal with this in paragraph 77 of our heads of argument. I won't detain you any further. Thank you.
Thank you, Ms. Mufangwa. We'll take a tea adjournment and reconvene at 12 o'clock.
Please forgive me. I should have done this in chambers, but I didn't, which is that I may need to be excused if we don't finish by 2, but my learned junior will do the reply if we get there.
Come again, Ms. Mofango.
I should have done this in chambers, but I didn't. I may need to be excused at 2 o'clock if we are not done, and my learned junior would do the reply if we don't manage to finish before 2.
Okay,
Thank you.
that's fine. Mr. Vine?
As the Commission pleases. We have put up detailed heads of arguments. Because of time, I'm not going to take the Commission through those arguments in great detail. Would it be okay if I sit, Commission?
Yes, if you elect to sit, you may do so.
It'll just be easier to deal with my paperwork if I'm seated.
It's not private or secret, it's in the public. The request. No, I'm saying the request is not private or secret, it's open.
Oh, yes, indeed. And some commissions I see counsel stand, and in others they said so. It seems to be a flexible option. Chairperson, Commissioners, perhaps I can just kick off by commenting on the complaint that an answering affidavit was only put up by Advocate Semenya SC and not by the Chair herself. I just make the short point that, at least in court proceedings, judges don't typically put up answering affidavits in recusal applications. The affidavits are put up by the parties. In terms of a quick roadmap, I'm going to deal quickly with the question of delay, the unreasonable delay. We will then look at the question of the previous roles played by the chairperson. We'll also take a look at the question of previous adverse findings made by the chair in certain judgments in relation to Mr. Zuma. And then lastly, we'll look at the various complaints made in respect of the chairperson's handling of the applications dealing with Advocate Semenya. So turning to the question of delay, or perhaps actually before I do that, I should deal a little bit with the question of the law. We agree with Mr. Improper that there are somewhat different tests in relation to actual bias and reasonable apprehension of bias. We set those out at page 7 of our heads. I won't waste the Commission's time by going through them. My learned friends have dealt with them in some detail. I will just highlight one aspect, that allegations of bias, particularly in relation to actual bias, especially on the part of a judge, must be substantiated by a proper factual basis and must be proved by the party alleging bias. And I'll return to that question a little later. Coming to unreasonable delay, and starting with Mr. Zuma, we've set out in our answering affidavit the periods in question, and we won't repeat those here. In terms of an explanation, we've heard from my learned friend Mr. Improper and Mr. Zuma's replying affidavit. And perhaps I can just quote from that replying affidavit. That quote's at the top of page 11 of our heads. The fact that the most recent improper conduct in respect of the Semenya recusal application constituted the last straw and trigger for the recusal application. Now, Chair and Commissioners, this is a revealing explanation. It's revealing because it was the alleged improper conduct of the chairperson in the Semenya recusal, which was the last straw and the trigger for bringing the application. So Mr. Zuma is effectively saying that but for the claimed improper conduct in the Semenya recusal, he would not have brought a recusal application. And Chair, that's an important point to make, because it suggests that all the other grounds that were in possession of Mr. Zuma, for example, the adverse judgments that Mr. Zuma claims the chair made against himself and her previous roles in the TRC and the MPA were insufficient to trigger a recusal application. Indeed, Mr. Zuma, knowing that the original hearings were scheduled to start on 10th November, was happy to proceed without seeking the chair's recusal, notwithstanding his knowledge of her involvement in these judgments and the public positions she held previously. That's a point I dare say also applies to Mr. Mbeki. So turning to Mr. Mbeki's delay, which we say is equally egregious, and we've set out the different time periods. Now, the explanation offered by Mr. Mbeki is in his founding affidavit at paragraph 64. And he said that he couldn't bring his application because Mr. Zuma only filed his application on the 15th of December, and he could only act thereafter. And my recollection is that the Mbeki application was then filed, I believe, on the 19th of December and circulated a few days later. So then it's quite clear, Commissioners, that but for the bringing of the Zuma recusal application, Mr. Mbeki would not have acted. And that's telling. If he didn't see the need to act before then, but was simply prompted by Mr. Zuma's application, we suggest that an application brought in such circumstances cannot be taken seriously. I'll deal briefly with the law on recusal and delay. It is trite law that legal applications must be brought as soon as an applicant is aware of the circumstances that warrant such an application, and this is particularly the case in respect of complaints of bias against judges. And this is because such applications go to the heart of the administration of justice and must be raised as soon as reasonably practical. We have quoted the case law. So there was a duty on Mr. Zuma to speak up, arising out of his long-held view that the chairperson was biased against him, arising from those judgments. He wasn't simply permitted to stand by and bide his time. And we submit, Commissioners, that bringing an application for recusal at such a late stage implicates the interests of justice. And it's not just the interests of justice of the parties, but also the wider public. The late bringing of recusal applications can have quite a massive impact. It can delay proceedings further, it can even derail them. This would not be in the interests of justice, and it would definitely be a problem for the families and the wider public to have to wait even longer, given how long they have waited for this commission. And there is a duty, of course, on both courts and the commissions to ensure that such abuses are curtailed. We're not arguing that Mr. Mbeki and Mr. Zuma have waived their rights in bringing such an application. But we do urge this commission to look at the circumstances of the delays, because our argument is that the long delay suggests that the apprehension of bias is not a reasonable one. I'm now going to turn to the question of the historical proximity, the occupational history the former roles of the chairperson in the TRC and the NPA. Now, according to Mr. Zuma, the mere holding of these positions make her distinctively unsuitable, and I'm quoting here, distinctly unsuitable and automatically disqualified for her present position. We've quoted the paragraph numbers in the footnotes. He's concerned that witnesses before the Commission could include her former colleagues and superiors, and that the issue of prosecution is directly linked to the granting or refusal of amnesty. However, Mr. Zuma has overlooked the fact that the subject matter before this Commission is not just a question of the history and what happened at the Truth Commission, and that the cases arise from the Truth Commission for prosecution, those cases that were not amnestied. That's not the subject matter of this Commission. The subject matter of this Commission is whether the TRC cases were blocked or undermined as a result of political or other form of interference. Now, there's no allegation that such interference took place during the chairperson's tenure at the TRC and the NPA. Mr. Mbeki makes similar assertions. He notes, for example, that Judge Khampepe was party to findings made by the Truth Commission against the African National Congress, having been involved in gross human rights violations, but they rather conveniently don't highlight the fact that the commissioners, including the chair, were also involved in making findings against other parties. Indeed, the primary finding, the main finding of the Truth Commission, was not against the ANC, but was against the former apartheid regime. It made findings against various other groups as well. And we suspect that Mr. Mbeki raised that point to put up an insinuation that the chair would be predisposed against the ANC, and the basis for that insinuation. Mr. Mbeki also suggests that because of her role in the TRC in making these findings and recommendations regarding prosecutions of those who were declined amnesty, that she would be predisposed in favor of justifying or defending prior institutional conclusions in which she played a role. Paragraph numbers are in the footnotes. Mr. Mbeki also refers to the chair's role in the NPA and again raises the question of institutional interest. Again, I have to say that the question of whether apartheid era crimes should be prosecuted is not before this Commission, and accordingly, those recommendations from the TRC do not have to be defended or justified. Now, perhaps here I'd just like to refer to some of the case law raised by my learned friends for Mr. Mbeki in their heads. The first case they refer to is Dumbu versus Commission of Prisons. It's a 1992 Eastern Cape case dealing with institutional bias. In that matter, the presiding officer, who happened to be the head of personnel in the prisons, had been actively involved in suppressing the grievances of the employees who were being disciplined. Now, Commissioners, that's obviously distinguishable from this matter. In that matter, the presiding officer played a direct and active role in acting against the interests of the employees who were before that tribunal. There's no allegation that Judge Khampepe, whether in the TRC or the NPA, played such a role in respect of the TRC cases. Mr. Mbeki seems to be saying that merely occupying senior roles in the two organizations is sufficient. He attempts to color this, to add color to this by claiming that discussions between the ANC and the former apartheid generals about the TRC cases overlapped with the period that Judge Khampepe was at the TRC and the NPA, that period during the late 1990s. But these interactions occurred quite separately from the TRC and the NPA. Nobody from the TRC and the NPA were present at those meetings or even aware that they were happening. Yet somehow Mbeki will have us believe that the mere overlap in time introduces a form of institutional bias. It's a fanciful claim. The second case raised by my learned friends for Mr. Mbeki is Council of Review and SADF versus Monarch. And in this matter, disciplinary action was taken against a soldier for disclosing a dirty tricks campaign by the army against the conscription campaign, and that senior army officers were sitting in that disciplinary council and they were likely to be loyal to the organization. And that was the founding of the court in that matter. But that was also distinguishable from our matter. There are no issues before this commission which are connected to the chair's time at the TRC and MPA that would cause her to be loyal to those bodies to the detriment of any party. Questions of loyalty simply do not arise in this matter. And then lastly on that point, Mr. Mbeki suggests that simply advising or acquiring personal knowledge relevant to the subject matter before this commission is a disqualifying factor. But the operative word, again, is relevance. The chair did not advise either of those bodies on the question of political interference, nor did she have any political interference. Nor did she have any personal knowledge of political interference at that time, because clearly it hadn't started as yet. So we would suggest that the claim of this unavoidable overlap between her past role and her present fact-finding responsibilities is neither here nor there. It is settled law that mere overlap between cases is not a ground of recusal. Turning briefly to the law on previous positions and how that impacts a recusal, my learned friends have conceded that mere association without more is not a ground of recusal, and reference has been made to the Safu judgment, so I won't repeat that. We do refer the commissioners to the matter of ex parte Khosan. It's a full bench, a full court matter of the Gauteng division, where that court quoted an Australian case by the name of Ebner. The citation is in the footnotes. And there, the following quote, which has also been approved by the Constitutional Court in Masuku, they stated that there must be an articulation of a logical connection between the matter and the feared deviation from the course of deciding the case on its merits. And in this matter, the applicants have failed to articulate a logical connection between the chairperson's former positions and the apprehension of bias. They failed to explain why her former roles will prevent her from adjudicating impartially on the question of political interference. Turning to Mr. Zuma's remaining grounds for recusal and the question of the earlier judgments, one of which resulted in his imprisonment. Citations are in the footnotes. Here we refer to the Electoral Commission matter. I'm not going to take you through the citation, it's all there. I'll just highlight one extract. The Constitutional Court stated judges often hear different matters relating to the same applicant without that providing a justifiable basis for recusal. And on this score, we note that Mr. Zuma hasn't explained what it is in that judgment that gave rise to his reasonable apprehension of bias or actual bias. He hasn't put up any specific examples or quotes from those two judgments. So there are no facts to consider apart from his bare assertion. And our complaint in that regard also applies to his reliance on these interviews with Newsroom Africa and News 24. He doesn't provide any quotes. He doesn't put up the interviews in evidence. All we got was a headline. I can see that he did attach it in argument, but that is strictly speaking not before this commission. So turning lastly to the chair's alleged bias in favour of Semenya, and this is the claim of private and secret advice allegedly provided by the chair to Advocate Semenya. Now again here, we don't have facts or evidence. We simply have allegations. And we told in Mr. Zuma's founding affidavit that at some future point, the Commission will be referred to the relevant evidence. Well, that evidence has still not been supplied. Mr. Zuma claims that the decision to withhold the evidence, and this is in the replying affidavit, is to protect ongoing sensitive investigations, and that at some undisclosed future time the evidence will be made available to the JSC or even this Commission once safeguards have been negotiated. Now, it hasn't been explained how Mr. Zuma came into possession of these alleged communications and whether such means were legal or not. And indeed, there's a possibility that the possession, the securing and possession of such communications may very well have been illegal. In footnote 69, we have set out the law in that regard. But it's right law that the test for recusal is objective, and it assumes that a reasonable litigant is in possession and has put up all the relevant facts. The test has to be applied to the true facts on which the recusal is based. The test emphasizes reasonableness in light of the true facts, not the technical legal nuances of the particular matter. In other words, if the factual foundation hasn't been put up or is wanting, then a fortiori, the apprehension is misplaced, and that brings an end to the inquiry. Now, in this matter, allegations have been made, but the true facts, the evidence, has not been put up. An allegation of bias has to be substantiated and proved by the party alleging it. And there's an interesting academic piece, which is quoted in our footnote 74, dealing with problems proving actual or apparent bias in South Africa. And there the learned authors suggest that when actual bias is alleged against judges, that's as heavy as the burden of proof of fraud, bad faith, or misfeasance in public office, meaning that the party alleging it must support it with cogent evidence, not mere assertion. So Mr. Zuma has failed to put up the evidence to support this claim. And this is a theme that has run through his recusal application, because he's also failed to provide the specific quotes from the judgments he relies on, and he failed to put up the media articles, which he also failed to rely on. And my learned friend, Mr. Improper, spoke about the cogency and sufficiency of evidence, and we agree that one has to look at whether the evidence put up has been cogent or sufficient. So has the evidence, is the evidence sufficient at the time that the allegation, regardless, and what we say is that regardless of how specific the allegation is, if the evidence hasn't been put up, then you can't claim that that is sufficient or cogent, and the evidence has not been put up. I just want to deal with a few matters that arose in argument, Commissioners. My learned friend, Ms. Muvongwa, states that in relation to the recommendation by the TRC that where amnesty was declined, prosecutions should follow. And she said an argument that, this is the bedrock as to why we are here. But at the same time, and I believe it's either in the written heads or in reply, Mr. Mbeki concedes that the prosecution of serious crimes such as murder, kidnapping, crimes against humanity and the like is a function of the rule of law and has to follow. This is because of our new constitutional order. And the mere fact that the judge may have been party to such a recommendation simply doesn't implicate the fact that the Commission here has to deal with political interference. As we've said time and time again, political interference simply wasn't on the table. It had not occurred at that time. And much has been said about the judge's role at the Human Rights Investigation Unit. That unit had to make recommendations to the NDPP about the TRC cases, but again, not about the subject matter. The subject matter before us is political interference. The judge was not working on that subject matter at that time. It had not even arisen. And then finally, turning to what was alleged in relation to Mr. Semenya's conduct around the leading of witnesses and the fact that the judge approved that request. From our perspective, this is an improper attempt to litigate that whole issue. And we may as well ask, why is that happening at this late stage? And we would suggest that it's because Mr. Mbeki wished to distinguish his application for recusal from that of Mr. Zuma. He did not wish to make common cause with Mr. Zuma. He wished to bring his own application. And since Mr. Zuma had not raised that particular issue, that would be a distinguishing feature. It would also provide some kind of justification for the late bringing of the application, because that was a more recent issue, and would allow them to then talk about the fact that over time these different facts crystallize, forcing them to take this 11th hour action on the 19th of December. Much reference was made to privacy, at least a private and secret arrangement. And if it was a secret arrangement, then the relevant correspondence would not have been forwarded to the NPA's counsel on the same day the request was made. It would not have been placed on the shared drive at that time. Indeed, it would not even have been disclosed at the 27 October meeting. It would only have emerged at the hearing itself. I'll do quickly with the claim that Mr. Mbeki only realized that he was seized with this commission of inquiry when he was issued with his Rule 3.3 notice in September of last year. Commissioners, that is a strained argument to suggest that he would only learn after receiving his notice that he would be involved in the commission of inquiry. He was deeply involved in the intervention application, and indeed even in those papers he indicated that he would be engaging vigorously in the commission of inquiry once set up. But frankly, even if one takes the time period from the issuing of the September Rule 3.3 notice, we're talking of a period of some 12 weeks. And to top it all, my learned friends even rely on those statements in their replying affidavits and arguments, and this isn't a question of a claim that they're still waiting for written statements. It's a spurious claim, commissioners. That they have statements. Their main complaint appears to be that they were afforded the affidavits before the High Court. Those affidavits are before this commission as well. Confirmatory affidavits have been put up by all those witnesses, confirming their earlier statements and updating those statements to the extent necessary with new information. To the extent needed, when those witnesses testify, they will confirm these different statements. So it is a spurious claim to say that they are still waiting for statements, and indeed they relied on these very same statements in their arguments and affidavits. So in conclusion, commissioners, we believe that the recusal applications are without merit. It's quite apparent that Mr. Zuma would not have brought his application for recusal but for the claimed information that they have in relation to Mr. Semenya's recusal. And yet They have not put up the evidence or the fact to support that particular claim. And in relation to Mr. Mbeki, it's more than apparent that they would not have brought their application but for the bringing of Mr. Zuma's recusal application. And Commissioner, such an opportunistic application cannot be taken seriously. For those reasons, we suggest that they have fallen short, hopelessly short, of dislodging the presumption that the chairperson, as a senior experienced judge, given her legal training, oath of office and intellectual discipline, would not bring an impartial mind to this matter, and the relief should be dismissed.
Thank you, Mr. Bani. Mr. Soni?
Thank you, Commissioner. Is it in order if I sat as well?
Yes.
Make it easier for me to look at my
Yes, you may.
documents. As my lady, please. Chairperson, Honourable Commissioners, we've submitted our heads in which we've addressed all the issues that we regard as relevant. We ask you to take all that into account. During the course of this presentation, out of no disrespect, we will refer to the applicants respectively as Zuma and Mbeki. Having regard to the issues raised on the papers and especially the heads of argument in our presentation, today we will address the following matters. First, the more relevant applicable principles applying to this application for recusal, the status and weight of the affidavits made by Semenya SC, whether the evidence presented by the applicants on the following matters is cogent enough to require the chairperson to recuse herself. First, the alleged institutional bias concerning the chairperson in respect of the TRC and the NPA, the chairperson's so-called handling of the application for Semenya SC's recusal, and the chairperson's alleged giving of advice to Semenya SC. We also will deal shortly with the undue and unexplained delay by the applicants in bringing their applications. Chairperson, I must say I had intended dealing also with the serious allegations made by in the Zuma papers in respect of the two Constitutional Court judgments that you penned, in light of the fact that it's not being dealt with by our learned friends for Mr. Zuma. We do not persist in that, except I will make a reference to it when I deal with the other matters. But I intended to deal with it, and we deal with it quite extensively in our heads, and we ask that what we said there be taken into account. Also simply point out that the fact that it's not being pursued does not in itself mean it should be ignored for the purposes of the overall impression of the application by especially former President Zuma for your recusal. Now, Chairperson, as regards the relevant principles, they are trite, but I would like to state the following. Firstly, an applicant must establish, and it's the applicant who must establish, one, the facts relied upon and a reasonable and objective, and that a reasonable, objective and informed person would on the correct facts reasonably apprehend that the judge has not or will not bring an independent mind, impartial mind to bear on the adjudication of the case. Point I want to stress, Chairperson, is the impartial mind. And that obviously, for the purposes of all application, would indicate a partiality in respect of one party as opposed to the other. But you would have heard this morning, Chairperson, that both the Zuma contention and the Mbeki contention is that their complaint is that you displayed partiality towards Semenya SC. Question I ask myself, and I ask that it be considered, is that a proper basis for an application for recusal? But I will deal with that more fully, but it is something that has worried me throughout the working through the papers in this matter. There is no indication that your partiality, Chairperson, relates to any of the parties at all. And it is a matter that needs to be taken into account when a ruling is made. Having said that, Chairperson, the second point I want to make is that the facts that need to be taken into account are the true facts that, as they emerge at the hearing of this application. That was emphasized by the Constitutional Court in SAFU 1 at paragraph 45, Chairperson. And I make that point because you've heard, especially in the Zuma contentions, that we've held back information, but on what we've given you, you must make certain findings. The point I will want to make, Chairperson, is that even when one looks at what the Zuma people say about those facts, they have no confidence that those facts take them over the line in regard to having presented the proper facts on which to bring an application for your recusal. Chairperson, in addition, we must accept, and even the Zuma applicants do not appear to dispute this, except they put a caveat to it, that when one is dealing with the application for the recusal of a judge, there are several different considerations that arise. Namely, that judges take an office to administer justice without fear, favor, or prejudice, and it must be taken into account that they have the ability to carry that out by reason of their training and experience. Now, Chairperson, we accept, Chairperson, that this is not a commission of law and you do not sit as a judge. But nevertheless, this is a judicial commission. It is a judicial commission precisely because it is a matter of public importance. That is why the President chose yourself and the two learned commissioners to assist you in advising him on the facts and providing him with recommendations. So the fact that you still hold the office of a judge is a factor that must be taken into account. And all the caveats in relation to recusal of presiding officers must be applied to you in respect of your judicial office. Now, Chairperson, we then deal with the question of the status of the Semenya affidavits. Chairperson, when one reads the Zuma complaint about Semenya SC, you will see that serious allegations are made. It is said he received secret and private advice from you. It is said that, in a sense, he relied on your goodwill to continue as the evidence leader. But having made all those allegations, the Zuma contention is that Mr. Semenya is not qualified to file an affidavit. Chairperson, that
your voice must not drop,
astonishing.
Mr. Soni. No, I was saying your voice must not drop.
Oh, sorry. That, Chairperson, is an astonishing and astounding statement. That somebody who holds the position of an evidence leader in a commission like that can be maligned the way Semenya SC was maligned, but must sit back and await his fate, as it were, without things being placed on record. And the only other person in regard to the serious allegations made against Semenya SC who would be able to deal with that matter would be yourself, Chairperson. And so what we see is an attempt to bring you into the fray. But once that attempt succeeds, Chairperson, it would mean you would not properly be able to preside at this particular inquiry. And Chairperson, we submit wisely you did not enter the fray. But we say, Chairperson, that all the complaints about Mr. Semenya's incapacity, as it were, to file an affidavit are without foundation. Let's just take one complaint referred to by the Zuma counsel, and that is that Mr. Semenya is conflicted. But, Chairperson, one just has to look at a situation where allegations are made in court proceedings against a lawyer. That lawyer must be entitled, notwithstanding that he gives advice to the client, he must be entitled to put his version across. And so the issue of conflict can never arise in that situation. Yes, he's an advisor, and in respect of the advice, he cannot depose to an affidavit. But in regard to allegations relating to him personally, he would be doing himself an injustice if he did not place the facts on record. Then, Chairperson, it is said that Mr. Zuma, that Mr. Semenya cannot make an affidavit without, in a sense, a confirmatory affidavit from yourself. That too, Chairperson, is an astonishing statement. The allegation made, and we will submit that there is no proper facts to back that allegation. But once that allegation is made, the allegation is there was an email from yourself to Mr. Semenya. Take that, and Mr. Semenya is as well qualified to talk about that issue as you are. And so to say there must be a confirmatory affidavit from you, again, is to require that you eventually recuse yourself from listening to this recusal application. And again, Chairperson, wisely, you did not. But putting everything else aside, Chairperson, what this Commission is required to do, or what you, Chairperson, in regard to this application is required to do, is look at all the facts that are properly presented to yourself. Assuming that the Zuma contention is upheld, that Mr. Semenya's affidavit be disregarded. We do still have the affidavit of the Kalata Group. And those are all the facts. And in a strange way, when one looks at the two affidavits, they are very similar in regard to the denials. And in regard to the denial relating specifically to Mr. Semenya and yourself, Chairperson, what is said both by the Kalata Group and the evidence leaders coincides. And so we say that would not be to the disadvantage of the Commission, whatever decision it took. Now, the Mbeki objection, Chairperson, in regard to that issue is that there must be a confirmatory affidavit from yourself, because Mr. Semenya is not in possession of all the facts. If they are talking about the facts or the allegations presented by Mr. Zuma, they have no right to deal with that. But clearly they're talking about Mr. Semenya's approach to yourself in regard to your involvement with the TRC and as Deputy NDPP. Now, those facts are on the table. It doesn't require a confirmatory affidavit from yourself dealing with your involvement. Those are matters of public knowledge. None of the parties has disputed it. We're back in the SAFU matter, my lady, where the facts not in dispute are what the Constitutional Court in that case took into account. And we say that is the approach you should adopt in relation to the allegations Mr. Semenya makes relating to your past involvement with the TRC and the NDPP. Chairperson, the next topic that I intended dealing with was the two Constitutional Court judgments. I'm just going to spend 2 minutes on that issue, Chairperson. One is, Justice Como asked my learned friend for President Zuma, but isn't the language strong? Well, that's what I intended saying in my head. What is important about what is said both in the heads of argument and in Mr. Zuma's papers about those judgments, in a sense, indicates, and to some extent, our learned friend for the Kalata group has touched on this, the manner in which Mr. Zuma makes allegations. If you look at the language, and it's not necessary for me to raise it, we've raised it in our heads. And yet, Chairperson, in the minority judgment on which Mr. Zuma relies, Justice Jafta says in his minority judgment that there is no doubt that Mr. Zuma's defiance of the Constitutional Court order that he had penned is deserving of punishment which might include imprisonment. And he describes Mr. Zuma's conduct as egregious. Now, I merely point this out, Chairperson, to say that Mr. Zuma's conduct in regard to what happened in the Constitutional Court was also criticized by the Constitutional Court, except that, as presented in our heads, the difference between the majority and the minority was, can imprisonment be based upon an application on by way of notice of motion, or need there be a criminal trial in terms of Section 35 of the Constitution? With the sole difference between the majority judgments and the minority judgment, both in the contempt application and the rescission application. And so my last word on that is the complaints that Mr. Zuma made, or the terms in which he brought it, are with respect highly regrettable. Now I deal, Chairperson, with the allegation relating to Mr. Semenya made by Mr. Zuma. Now, in his founding affidavit, Chairperson, the allegation is that there was a private and secret communication by you to Mr. Semenya. Mr. Semenya responds to that and says, but I find it offensive that you say this is private and secret. I'm in regular contact. That's how commissions work. That's my role as the commission leader. I deal with the chairperson, I deal with the other commissioners. That's how all commissioners work. And so that is now described in the replying affidavit as a red herring. And so now the allegation is, but there was a communication, but the caveat is, there is this communication which I call secret and private advice, but I'm not going to tell you about it. And Mr. Semenya, in response, and properly so, says, but how do you expect me to respond to this? You've described this as something private, as something secret. It's not that. Tell me what it is so that I can properly respond. And you, in any case, bear the burden. Tell us what it is.
Yes. If a party says that, usually it is said that Mr. Semenya was required to prove a negative. You see, if you have to prove what you do not know, you are required to prove a negative. How do you do that?
Indeed, Justice Como, in fact, it's perhaps was at the back of my mind, but I've never articulated it that way. But that is exactly what it is, putting a party at a disadvantage. And perhaps I fell into that because of something else that I wanted to say, but that's not to take away from the point you make. Thereafter, seeing that the affidavit disarms the communications between the chairperson and Mr. Semenya, in reply, the contention is, and I say contention or allegation is, that there is an email of the 5th of November which proves, according to the affidavit, proves this communication between the chairperson and Mr. Zuma. Now, between the chairperson and Mr. Semenya. The problem with that assertion is that the application for recusal was only, the papers were first filed on the 12th of November. So on the 5th of November, it is highly, highly unlikely. I'm not going to say impossible, but there is no basis on which this commission could find that there is an affidavit on the 5th of November dealing with a recusal, advice on a recusal application, which is only going to be made on the 12th of November. But the problem doesn't end there, Chairperson. In the reply, at paragraph 23.5 of the reply, former President Zuma says, the decision not to provide some of the evidence pertaining to that allegation was not without cause, as he describes it, but based on the pleaded imperative to protect inter alia ongoing sensitive investigations and the like. Such evidence will be made available to the JSC or even this commission once specific safeguards have been negotiated. The implication of that, Chairperson, is we submit clear. We accept that what we've presented will not satisfy the reasonableness test. But we ask you to take into account that we have a just cause. Namely, we need to protect someone. Well, that may be so, Chairperson, but that is not the basis on which your decision must be made. As I've stressed, and that's paragraph 45 of SAFU, evidence on which your decision must be based is the evidence that is presented before this commission. The evidence that is presented before this commission indicates that in Mr. Zuma's own mind, he's aware that what he has presented is inadequate. It would not satisfy any reasonable test. And so we submit that on that issue, the finding is that no case has been made out in regard to the communication between you and, or the alleged communication between you and Mr. Semenya. Now, we also point out that in regard to the position of Mr. Semenya, the Mbeki position is quite different. They say that, or their complaint is, as they call it, the manner in which, Chairperson, you handled the recusal application. Now, our learned friend, Mr. Varney, made the point, and I'll just accept that he's made it sufficiently well, except to say this, that effectively they want to re-argue that point again. There was an agreement between the parties as to how the evidence of the collateral of anybody would be dealt with, and there was a subsequent decision by yourself, Chairperson, as to the fact that the Kalata group or Kalata's counsel could lead that evidence. And that was all agreed. That matter is done and dusted with.
And it was open to the others to do the same, other legal representatives to do the same.
Indeed.
If they wish, if they are so minded.
Yes. But I also want to make the following point, which we make in our heads. If you look at the merits judgment, which we refer to in our heads, their complaint, Chairperson, is you didn't handle the matter properly. But the fact that a matter is not handled properly is not a ground for recusal. It can be dealt with on some other occasion. Your right as a litigant affected by that judgment in a case like this is to take it on review. It doesn't form a basis for recusal or a ground for recusal, no matter how strongly one feels. The law doesn't allow that.
Mr. Soni, as I understand it, the argument from Mr. Mbeki's team is even more. It says it was a failure to provide reasons.
Sorry, a failure?
A failure to provide reasons.
Yes. Well, Commissioner Gabriel, the same would apply. If you don't have that and you're prejudiced by it, it's a ruling. You can't do anything at this stage. At the appropriate stage, you would take the matter on review and indicate why that ruling would affect you. But it doesn't provide a basis for recusal. And if I could just, there is a judgment, the take and pay judgment, which is referred to at, I think, paragraph 18 of the Mbeki list of judgments. Take and pay versus, I can't remember, but at paragraph 5, Justice Harms, it's Take and Pay v. Standard Bank, Justice Harams refers to a judgment of Justice Schreiner in the Silber case, State versus Silber, where exactly that same point is made. That in certain instances, what happens in court is not a basis to apply for the recusal of the presiding officer. Now, the Mbeki case is and in some way the Zuma case is, even if some of our allegations are not looked at, are not good enough, when you look at them collectively, or as they put it, cumulatively, the effect is to justify the recusal. Well, that approach was first dealt with in the Safu matter, where Justice Chaskelson or the court dealt with it as saying that the contention was that all the complaints should be put into a basket, and the approach was that the only complaints that will be put into the basket are the complaints that pass the test for reasonableness and what would pass the Safu test in each case. That issue was also in the recent Maritz judgment. The same approach was used where there were about 5 complaints against the judge, and the same approach was asked to be adopted, and the court said, it can't be that a complaint that doesn't pass muster reinforces a complaint that doesn't pass muster, but the two together do pass muster. And we asked the court to adopt, we have asked you, Chairperson, to adopt that approach. Chairperson, I know I'm fast approaching.
You are fast approaching.
I'll make 2 further points, Chairperson. One is the issue of delay has been dealt with quite adequately in the presentation of our learned friend for the Kalata group, and we align ourselves with what is said in that regard. But finally, Chairperson, may I just say this?
Mr. Soni, could I ask you please to come forward a bit to the mic?
I'm sorry.
Okay.
Can I conclude with 2 propositions I want to make? And they are contained in paragraphs 87 to 92 of our heads. It has been held that the presumption in favor of impartiality must always be taken into account when conducting an inquiry into whether a reasonable apprehension of bias exists. And we submit that that would apply to bias as well. And we say the assumption that judges are individuals of careful conscience and intellectual discipline, and a judicial officer will not lightly be presumed to be biased, is a presumption that is not easily dislodged. And one final proposition, the bias in this case, as I stated right at the outset, is a very strange one. It is against the Commission's, or in favor of the Commission's evidence leader, but no bias against any of the parties who complain about all the matters that have been dealt with is suggested. We suggest that that is because there is no bias against them and no real reasonable apprehension of bias. Chairperson, those are our conditions.
Can I just, I'm not so sure how you can deal with this, but because Mr. Mpofu raised it, you know, there's this rule of compensatio. He says, basically, I point out that Mr. Zuma used strong language But equally, Mr. Semenya compensated by also using scurrilous what language. What do you say about that? Because Mr. Semenya can't answer that. You need to say something, if you can say something about that at all.
Justice Como, I listened to that exchange, and my response is this. Mr. Semenya was talking about litigants who appear before this commission complaining about what happened during the course of proceedings. He complains, the Zuma complaints are against a constitutional court judge, but not alone, but the 6 other judges or justices who concurred in that judgment. That is what is regrettable about the nature of the language used. We submit that such, if I can put it properly, intemperate language ought not to be used when describing persons who form an important part of our democracy and undermine, in fact, the entire judicial system. So the point I want to make is, it is so that the language is strong. But what one must ask is a litigant not entitled to speak in that language against another litigant, as opposed to a litigant speaking in that language about a person who held office in the highest court of our land? That we submit is an essential difference which all reasonable people will accept and make.
Thank you. Thank you, Chair.
Thank you, Mr. Soni. We'll adjourn for lunch and we'll reconvene at 2:10.
Yes, please.
Sorry.
2:10.
Yes, I wanted to make a suggestion because my little friend Ms. Mapwapwa suggested that she has to go, but she should go.
Yes.
But only if it's still within her time.
Ms. Muvangwa?
Yes, I would need to leave here at 2. I have a doctor's appointment that I cannot miss, so I would have to leave here by 2.
Yes. No, you.
I was going to make a proposal that maybe she should reply now and then we take the lunch time.
Yeah. Is that fine, Ms. Muvangwa?
Yes, I'm deeply indebted to my learned friend and to the Commission. I'll be very brief, though, in reply.
You have to.
I will, I promise, subject to your questions. So I would like to start by replying to my learned friend for the Kalaza group, who says that Mr. Becky says in his affidavit, well, the proposition that was postulated was that had it not been for former President Zuma's application, President Becky would not have brought the application for the recusal, and reliance, thank you, was placed there on paragraph 64 of the founding affidavit. Commissioner Khomo, we spoke about that earlier. That affidavit does not say what my learned friend says it says. The affidavit, that particular section is headed condonation, And there, former President Mbeki explains the delay and what happened during the entire time period. He doesn't say he would never have brought the application, but for President Zuma's application. To say that would be a misrepresentation. If I may, the paragraph reads as follows. For those following, it's at page 22 of the founding affidavit, and it says, midway, I am advised by my legal representatives that the application on behalf of Mr. Zuma was filed on 15 December 2025. It was necessary for the legal representatives to consider the substance of the grounds of recusal so that a decision could be made whether or not to support the application. Once that assessment was made, that was done, I beg your pardon, this application was finalized and delivered as soon as possible. At no point does he say, I wasn't going to bring it back for that application at all. He says something completely different. The second point I want to respond to is there was an assertion made that the TRC made findings against other parties as well, and not just the African National Congress. So to say that the TRC pronounced on the amnesty applications of the African National Congress is at best hysterical. Well, the problem is that the Kalata groups alleges that the TRC cases were frustrated because the ANC 37 were denied amnesty and did not want to be prosecuted. So the claim is that they then engaged in political interference of the prosecution and investigation of the TRC cases. So the ANC is definitely relevant. It is not my client's case that the TRC only made pronouncements in relation to the ANC, but the ANC is very much relevant because it is centralized by the Kalata applicant's claim itself. Third point is on the issue of the private arrangement. My learned friend for the Kalata group said that the arrangement was never private because it was disclosed to the parties. It would be recalled that the correspondence that I referred to earlier was only became known to the parties on 27 October. Not even the NPA had it. And the convention in any event is once proceedings are underway to copy everybody. The NPA, my clients were not in September before the commission, but the NPA was. The NPA was always a party cited in the court papers. The NPA did not have the correspondence. So it is not correct that it was not private. Had it been not private, everybody would have been copied and been provided with the correspondence as soon as it was made on the 18th of September. On the issue of witness statements, I don't wish to belabor this point. The fact is that there are no witness statements that were created for purposes of this commission. The record speaks for itself. If I could perhaps just invite the commissioners to make a note. In the replying affidavit to Mr. Semenya's answering affidavit, attached the following documents, and I will say what the purpose is. Purpose of those letters from my client's legal representatives was to ask repeatedly that witness statements please be provided because it was difficult for them to answer on the basis of copy and paste from High Court papers. Those are TMM2, dated 3 November 2025, TMM3, dated 7 November 2025, and TMM4, dated 9 December 2025. So that's as far as the reply goes for the Kalata group. With respect to the my learned friend for the evidence leaders of the commission, she posited the question, is partiality towards Mr. Semenya SC a cause for recusal? We say yes. The context, Commissioner Gabriel and I had a conversation earlier about taking into account the totality of the available evidence and information rather, I can't remember the language we used, but the totality of that context is very much relevant. It is relevant that the making of a private arrangement with one of the parties before the commission would give rise to an apprehension of bias without the inclusion of all other parties. So that must be taken into account, and that's why we say yes. And number two, it's also relevant, the acting in disregard of the Commission's directive without consequence. That would also give a reasonable apprehension of bias, and that's why we say yes. We say yes for the further reason that procedural fairness is an aspect of fairness, and it wasn't there.
Are you traversing new ground?
Can I just draw attention, because I'm not quite understanding the synthesis here, but draw attention to the replying affidavit to Mr. Semenya SC's answering affidavit, and I'm being told to draw attention to paragraph 31, which is at page 15, as well as paragraphs 32. It speaks to the required independence of evidence leaders.
So how does that translate into bias on the part of the chair?
Yes. So the fact that there were complaints about conduct by the evidence leader, which implicates one of the parties before the commission, and there was no consequence, gives my client the apprehension of bias in the sense that so let me take it a step back. There are a multiplicity of parties before this commission. The commission is the adjudicator, if you will. The evidence leader is an extension of that adjudicator, if you will. It is the evidence leader that is to remain neutral, elicit information in a balanced fashion. Now, if you have that very same person engaging in private correspondence arrangements with one of the very parties before a commission, that does give a reasonable apprehension of bias, especially more so in circumstances where, in the case of my clients, they are accused of having broken the Constitution, and the consequences for them are really high. I cannot take the point any further than that, but to underline the fact that there is a lack of independence, and that there was no consequence, which means that the lack of consequence on the part of the evidence leader indicates that the chair is predisposed to permitting the evidence leader to continue regardless.
But you accept that it's the chair who is the trier of fact?
I accept that it is the chair who is the trial fact, but I also accept, as advanced earlier, that the evidence leader is an extension, if you will, of that very entity, the commission. And that's why the evidence leader deposed to an affidavit on behalf of the commission. And, okay, I'm now told by my boss to please read this because it answers the question directly. So I will do that.
You don't have to accept it.
What paragraph?
Paragraph 31 of the replying affidavit.
You've taken us to that at page 15.
I did.
Yeah. And the other one?
And paragraph 32.
You've taken us there.
I need not read it? Could
No.
I read it? No, thank you. Okay, they said no. And then on the role of the chairperson in the NPA. I hate this man. So one example I will say is this. It was claimed that the Human Rights Commission, the claim was that the role of the chairperson in the NPA was a matter of public record. We disagree. It was claimed that the Human Rights Commission advised on policy. We then queried on what exactly the chairperson's role was. The fact that there was a query and never a response means that it was never a matter of public record, because had it been, my clients would never have queried. Advocate Semenya SC, who deposed on behalf of the chair and the commission, would have answered the question. The latter applicants would have answered the question, the group would have answered the question. So that's all there is to say about that. And then the last point I will make, two more points. my learned friend for the evidence leader said that the fact that nothing turns on the fact that no reasons were provided. If we were disgruntled, my clients were disgruntled, they could have brought a review. That's no answer. And I'll say why. The test for an apprehension of bias is not whether there is an alternative remedy somewhere. It is simply whether, armed with the information that you have as a reasonable person, a reasonable apprehension of bias would ensue. Whether there is another remedy somewhere else is of no moment whatsoever. The last point I make is on this idea that of cumulative assessment of the ground. That's not our case. We were very clear to say our grounds are 1 and 2. The third thing in my chronology was to say, never mind that they stand alone, I also want to invite the commission to do this one other thing. It was never my client's case to say they only make a ground once you bundle them up. And those are the submissions in reply.
Thank you, Ms. Muvangwa.
Thank you so much.
I hope everything goes well with you with your doctor's appointment.
Thank you so much, Justice Khampepe.
We'll adjourn and reconvene at 2:20. Do you have a pen? Pen. Do you have a pen?
So,
Then the pen.
oh yes, I have two. Can I just?
Advocate Mpofu, the ball is in your court, sir, for a reply.
Thank you very much. Chairperson, Chairperson, I'm going to deal with, I'll just change the sequence this time. I'll deal with the second ground first, which is the reasonable apprehension of bias ground, which I said earlier I was not going to deal with extensively because the making applicants obviously accept that as their main ground. I just want to make one point before I come back to the main issue of actual bias. It's very clear that both the talented group and the evidence leaders, despite professing otherwise, and especially the evidence leaders, still don't appreciate the distinction between reasonable apprehension of bias. The reasonable apprehension of bias test and actual bias test. So, the record will show that Mr. Soni Malena's friend conflates the test more than 5 times. I stopped making notes about it. Because he says, no, you can't say that there was this advice given and so on because a reasonable person would not apprehend so for this and that other reason. That's mixing up the test. When it comes to the actual bias test, there's no question about any reasonable person. But let's come to the reasonable apprehension test in relation to the second ground. We do, by the way, in respect of the occupational history ground, rely on only on reasonable apprehension of bias. As far as that ground is concerned, we don't assert actual bias. So that's what I want to address. So we're told that one of the defenses, or actually probably the only defense apart from the 2003 thing, is that the subject matter of this commission is different from what was being dealt with by the TRC Amnesty Commission. But that argument misses the point about what the essence of the complaint is. And you can't expect the so-called reasonable person to make all these nice, fine distinctions about, where the mandate of this one stopped here, the other mandate stopped there. The reasonable person will ask in broad terms, is it reasonable to apprehend a perception of bias if you have somebody who is a decision maker now in relation to decisions that he or she was part of making? They're not going to, do the fine nitpicking that Mr. Soni is inviting us to do. We know, it has been said, one of the most famous quotes about the reasonable person comes from Justice Holmes in S. versus Berger. And he said, one quote, "One does not expect of the reasonable man, or the bonus pater familias, any extremes such as Solomonic wisdom, prophetic foresight, chameleonic caution, headlong haste, nervous timidity, or the trained reflexes of a racing driver." In other words, the reasonable person must be taken as the man in the omnibus or the woman in the omnibus who takes a globular view of these issues. So even if you use the reasonable person test in relation to the occupational history ground, it should be self-evident that when there's a commission whose key function is to investigate reasons as to why the NPA did not follow the recommendations of the TRC Amnesty Commission committee to prosecute certain murderers. Somebody who is associated, it's a double whammy, associated both with the NPA that allegedly failed to prosecute and the Amnesty Committee whose recommendations the failure to prosecute was not carried out. To ask the reasonable person to think, oh no, there's a comma here and another sub-paragraph is really just playing games and not applying the proper test. So that's the one thing. So the TRC Association and the NPA associations are, in our respectful submission, themselves grounds which, and we accept that this is not for this commission. The president is the one who did the appointment, but that appointment, for what it's worth, and in the correct forum, is itself to be criticized. Now, then we come to the other ground. I want to come last to the actual bias ground. Justice Khomo says to my learned friend, Ms. Muvangwa, that what we expect is that Advocate Semenya must prove a negative. But where does that come from? Nobody is expecting Advocate Semenya to prove any negative. There are positive, pointed assertions that are made about being given advice, what that advice is about, or how it should be conveyed to Advocate Soni, and so on. Where's the negative? Those are positive assertions. If someone wants to disprove that, it's simple to say, it has never happened. I was never given such advice. I don't know what you're talking about. It's not as impossible as it is portrayed to be. That's all you do. If I receive an affidavit today that says, today I was in Cape Town doing this and the other, I'll say, no, I was at the commission, I was arguing a matter, and so on and so on. I'm not proving any negative. If somebody makes any assertion positive that I was doing something right at this hour, it's within my gift to oppose that. So let's not, again, create a case that is not there, because the case is here in front of us and it's very simple. Then there's the issue about the so-called language issue. Firstly, I don't know what this language, we're not told what the language that Mr. Soni is complaining about is. But assuming it is contained in the affidavit, I honestly don't know what it is, except for what I explained this morning to Justice Khomo about the fact that somebody who has been subjected to what I've described as detention without trial is entitled to feel strongly. And if they're entitled to feel strongly, well, then they're entitled to express those feelings strongly. I don't know what it's like. I was only detained without trial under apartheid. But if someone had asked me to describe that experience, I don't think I would do it in hush-hush tones. So that's really the only answer. And it's very rich coming from Mr. Soni to complain about language. When he has, in their papers, they've accused us of the things that I cited earlier, Justice Khomo. And not only that, sitting there, in the same breath, he was casting aspersions on President Mbeki as being basically devious and disingenuous, because the only reason that he wanted to do this application was because he didn't want to because there's the Zuma application and so on. All the things, the ill will that he was ascribing to, not only to President Zuma, but to President Mbeki. And by the way, he says the reason why he takes exception, or why there must be different treatment, is because Mr. Semenya is making comments about a litigant, and Mr. Zuma is making comment about an esteemed judge who held high office. Well, both President Zuma and President Mbeki held high office as well. So if it's going to be a contest as to which office is higher than which, well, then so be it. So you can't be entitled to castigate people who held high office if your philosophy is that people who hold high offices should not be castigated. What's sauce for the goose is sauce for the gander. Now, the issue of another mistake that, to put it politely, that the evidence leaders are making is the issue of the context. You know, it's been said that in law, context is everything. So we're told, for example, about that Advocate Semenya, in relation to the issue about the affidavit, is entitled to do the affidavit because judges typically don't do affidavits, particularly in matters that concern them, which is true. But that's not the point we're making. The point is that counsel also does not make affidavits for the same reason. Counsel ordinarily doesn't make affidavits about cases that they are involved in. But in this particular case, all we are saying is that you have a situation, and this cannot be controverted. You have a situation where somebody says, I'm acting on behalf of X. Everyone is entitled to act on behalf of anybody. But once that authority is challenged, you can't keep mum. I mean, I don't know. You can't then say, if someone says, I'm authorized by my learned friend, and someone challenges it, and then I do nothing, then that challenge is requited or unanswered, and therefore it remains like that. There was nothing stopping the evidence leaders from putting an affidavit or saying no, this and that and the other as an explanation. So every allegation, and Mr. Soni really is testing our intelligence, because he says that he concedes. He says, yes, we accept that Advocate Semenya could not make an affidavit about the matters raised in the application, but he can make an affidavit about matters that affect him personally. In other words, the allegations of giving advice and all that. But that submission can only be made by somebody who has never read the affidavit of Advocate Semenya, because that affidavit says zero about what he says it is entitled to do. It says exactly the one that he has considered, because it says no about the judge and her history and so on, things that are clearly in the personal knowledge only of the judge and not Advocate Semenya. The part that Advocate Soni says Advocate Semenya is entitled to attest about, he doesn't. Because he's right. He could have said, no, I didn't receive that advice. Oh, no, I was not in South Africa at the time or whatever. But he says nothing about that. So that is a concession by the evidence leaders that the affidavit in front of us, the one here, is of the prohibited kind. And the one that they say is of the allowable kind is not this one. So what more do we really need? And that's why I was saying, when you do a confession and avoidance, if you don't have the avoidance, you are only left with the confession. And that's what we have in this case. There's a confession that says, effectively, the defense being given to you, this panel, is yes, the advice was given. Yes, it was, because those are not disputed. Yes, it was to say, to tip or to coach Advocate Semenya to give advice to Advocate Soni as to how to argue the case. Those are the allegations. Coaching, collusion. And, but no, the avoidance, attempted avoidance is, no, but they talk all the time. Really? How does that address the pointed accusation of giving advice whose content is given and whose impropriety is patent? It doesn't. And therefore, those allegations must be taken as given. Then Mr. Soni says that correctly says that no, I think it was Mr. Vani. It's that a predetermined outcome. I mean, the most typical manifestation of the Nemo Iudex rule is arguing a case in front of somebody who has a predetermined outcome in their head. That's the most, because what's the point then? You might as well just keep quiet and say nothing. Because whatever you say, you can quote 1,000 books and what have you. If the person has a predetermined outcome, it's not going to succeed. That is what is called bias. And what is better bias or demonstration of a predetermined outcome than somebody saying, when there are two adversaries, you must do this, you must do that, you must do that. For what reason? So that you can win, so that my predetermined outcome must prevail. So, sometimes lawyers complicate things. The simple example is this. You have a soccer game, and the referee goes to the change room of the other side and say, no, you must change, you must play this one. Be careful of that striker, and so on. Who does that? It's which team, once it gets to know that knowledge, that the referee went to the change room of the other side and advised them on how to win the game, would you continue playing the second half? I wouldn't. Because what's the point? You might as well give them 10-0. We're not going to waste our time playing this game. And that's all we're saying, really, to simplify it. We are saying we cannot be expected to play a game that is fixed. And it is not true that, or rather, it is mistaken for my learned friend, Mr. Soni, to make the following submission, that simply because the alleged bias is in favor of Mr. Semenya, then what are we complaining about? I mean, that kind of submission boggles the mind. How can parties that are going to be subjected to a process in which Mr. Semenya is the evidence leader, he's going to be questioning those parties, be told that, well, so what if Mr. Semenya is favored? And yet the same parties say that in their heads of argument, Mr. Semenya must be regarded as a prosecutor. They say the best way to understand his role is you must regard him as a prosecutor in a case. Now, if we follow their own analogy, which litigant would say, no, only the prosecutor is biased, and the judge is in favor of that prosecutor, but that bias is not against me? I mean, what is that? I can't even work it out in my own head, what that submission is. In short, the mere fact that there is bias to do with one of the players, whether they're a prosecutor or an evidence leader or whatever, affects both presidents directly. because they are the implicated parties. And just on the jeopardy, I think in the heads of Mr. Mbeki, this point is made even better, which is that one of the mandates of this commission is to recommend criminal prosecutions. So the prejudice to those people facing possible criminal prosecution is clear and manifest. I don't think I need to belabor that point. And at paragraph 43 of our heads of argument, we make the point, and we quote the famous case of Rare Pergamon Press Limited. And this covers both the point that I just made and also the so-called inquisitorial process point, which is that simply because the commission makes only recommendations, it doesn't matter. It can be biased, basically. That's not true. This is what Lord Denning said in Pergamon Press, talking about something even less than this commission. It is true, of course, that inspectors are not a court of law. We concede that. This is not a court of law. Well, actually, that's a point we made earlier. Their proceedings are not judicial proceedings, it says. They are not even quasi-judicial, for they decide nothing. The point made by my learned friends in their heads. They determine nothing. They only investigate and report, like this commission. Investigate, make findings, and report. But here's the sting. But this should not lead us to minimize the significance of their task. They have to make a report which has wide repercussions. They may, if they think fit, make findings of fact which are damaging to those whom they name. They may accuse some, they may condemn others. They may ruin reputations or careers. And Lord Denning went therefore to say, therefore, they must be held to the standard of fairness. And the standard of fairness is manifested in the two rules of natural justice. The most well-known is the aude alteram partem, but its other cousin is the nemo iudex. And if those standards have been breached, or perceived to be breached, reasonably so, then that should be the end of the matter, honestly. And if, on top of that, the allegations that have been made are not disputed, then whether it's the actual bias or the other case, must be then decided on the admitted facts. The admitted facts are set out clearly in the affidavits. The admitted facts in relation to the actual bias are set out in paragraph 38, 39, and 40, and they have not been denied. And my learned friends, both Mr. Vani and Mr. Soni, thankfully agree with me, or at least expressed agreement on the issue of the sufficiency or cogency of evidence. And the only question that stands before you, honorable commissioners, is whether on the evidence that is presented, not the evidence that is not presented, on the evidence that is presented, and you'll find that summarized, in our heads of argument at paragraph 56. So on this argument, is there a case or not a case for actual bias, alternatively reasonably apprehended bias? And we say, under this topic, two pointed accusations have been leveled against the chairperson, namely collusion in the form of 1, collusion by giving legal advice, 2, and or sharing helpful research with one party to the dispute before her. 2, coaching in the form of pointing out potential pitfalls to the implicated party and even going as far as to propose what instructions are to be given to the legal representative of that party, Advocate Vasoni SC. 3, doing all of the above without the knowledge of the applicants, privately and or secretly. In short, the conduct was undisclosed. I dealt with this earlier. 4, doing so with the intention to assist Advocate Semenya to succeed in the recusal application, which was yet to be argued before the very same chairperson. And 5, to indicate knowledge of unlawfulness, conveying the impugned message from her private email address and not the one officially assigned by the Commission. And you can add the 6, what is referred to in the replying affidavit, which has not been disputed, that there were not only those emails, but there were also WhatsApps. So the point is that, is this...
What about the WhatsApps?
If you go to the replying affidavit, sorry, Justice.
That is your point 56.6.
That was the head, but now I'm going to the affidavit. The reply. Okay, I'll find it now, Justice Home. Let me just paraphrase. What we say in the reply is that I have to read it as it is
Yes,
put here.
you paraphrase if you wish.
Yes. Please find the reference to the WhatsApps. Sorry. Yes. I'll paraphrase it so long. Malena Junior will find the passage. What is alleged in the reply is that, firstly, it says the email was sent on the 5th of November, as my learned friend alluded to. And then secondly, it says it was sent on the private email. But then it says, if this is denied, which was the same theme as in the founding affidavit, then the challenge is made for the Commission to produce the relevant emails and WhatsApps. Okay, my learned friend is not finding it, I'll find it myself. Paragraph 23.6. Thank you very much. I'm indebted to the Galate group. Yes. This is what it says. We say at 23.5, just for context, the decision not to provide some of the evidence pertaining to that allegation was not, quote, without cause, but based on the pleaded imperative to protect inter alia ongoing sensitive investigations and the like. If I may pause here, we all know that certain information might be withheld to protect investigations, whistleblowers, and all sorts of things in general. There's no basis for Mr. Vani's suggestion that that would be illegal. Such evidence will be made available to the Judicial Service Commission, or even this commission, once specific safeguards have been negotiated. Obviously, these are to do with confidentiality and all that. For now, it is sufficient, this is the paragraph, to reiterate that I maintain, says President Zuma, that the chairperson indeed gave alleged advice in writing, and it will become available once the necessary discovery processes have been followed in the appropriate forums. To be more specific, on 5 November 2025, the chairperson personally wrote to Advocate Semenya SC advising him of research which would be helpful to his case and proposed that he should share with Vasoni SC, who was representing him in the Semenya recusal application, which was scheduled to be argued before the very same chairperson. This correspondence was notably not sent from the official commission email, but from the chairperson's private email address. On another occasion, the chairperson specifically advised Advocate Semenya to watch out for and or deal with paragraph 45 of the founding affidavit in the Semenya recusal application, which alleges that Semenya SC had violated a directive of the Commission. Again, if all of the above is denied, I invite the Commission and or the respondent, in the interest of transparency and openness, which are values of our Constitution, to disclose to the public all the email and WhatsApp correspondence exchanged in the relevant period between the two individuals. So that's the reference to the WhatsApps, Justice Kong. So the point being made, again, by the way, this was the second time this challenge was being made. In the founding affidavit, we say, if you deny this, then you must provide you must provide the information, the avoidance, quote unquote. That's not done. In reply, this challenge that I've just read out is made again. Until today, none of that has been forthcoming. And there's no denial. Again, of course, if all this was just mumbo jumbo that's made up, people will say, what are you talking about? What email? There's never been such an email, or there's never been such WhatsApp communication. That is specifically and actively not done. You know, it's actively avoided to deal with these allegations. Whether you combine these with the ones that were made, the 5 that I read from paragraph 56, and until today, nothing has been said. Which decision maker can say, in the face of a one-sided serious accusation, which has not been responded to, that accusation must be wished away? It can't be. You have no choice, the three of you commissioners, but to accept that the facts as alleged in the founding affidavit and the replying affidavit are there. Your only job is to say, if these facts are true, if such advice was given from a private email and so on and so on and so on, is that not evidence of actual bias? One. If it is not, would a reasonable litigant in the position of former President Zuma not reasonably hold a perception of bias or apprehension of bias? Those are the only two questions. And the answer to those questions is yes and yes. In any world, anywhere, whatever anybody wants to say, the answer to those questions will always be yes. There's nobody who's allowed to be a decision maker and yet participate. You can't be a referee and a player, as the saying goes. If you must choose which one you want to be.
Mr. Mpofu?
Yes,
I must draw your attention to
the time. Yes. Thank you, Justice Khampepe. Yes, I'll wrap up. Let me just check my notes.
You are actually 15 minutes over.
Yes. Okay. Well, all right. I was not counting. I'll take your word for that, Justice Khampepe. Yes. Okay. The point I made. I don't have to reply to this because there was no countervailing argument. But the point about the only problem is that Mr. Soni, I think, just ignored what I was saying about the fact that this is not about the recusal of a judge, this case, the one we're talking about now. It is about the recusal of the chairperson of a tribunal who happens to be a judge. So the test is not the test of somebody sitting in judicial proceedings. That must be made clear. And therefore the presumptions don't apply mechanically as Mr. Soni would like us to believe. Then Mr. Soni says, or one of them says that Mr. Zuma has not put up the evidence. I think I've answered that. He has put up the evidence. Is the evidence complete? We are the first ones to say it's not complete because of the withholding of some of the evidence. But that's not the question. Is the evidence sufficient for the finding that we want this tribunal to hold? The answer is yes, it is sufficient. And then, sorry. Yes, the last point, hopefully.
Not hopefully, Mr. Mpofu.
Okay, last
but
point.
It should be the last point.
Yes,
I
no,
think
it is Justice.
Hope springs eternal.
Yes, well, we live in hope. Oh, yes. Okay, I'll hold this. This is the real last point. The point I wanted to make, no, this point is not mine, it's just Ms. Sokela wanted to just make one point. In fact, I should have allowed her to do that before I started. So with your permission, when I finished, she just wanted I completely forgot. She assured me that it's really 1 minute, not a minute. Now, the last point I wanted to make is this, Justices, Homer and Commissioner Gabriel. And it has to do with the issue of so-called unreasonable delay. It is now common cause between us as parties, from what I heard, that even if, let me put it that way, even if the unreasonable delay point was good in relation to the occupational history, which obviously was known before, and in relation to the both the TRC and or in relation to the judgments of the Constitutional Court, obviously, that point cannot be good in relation to the main point that is raised by President Zuma, which is the giving of the legal advice. So even if one, that was correct, and B, even if it was a complete bar, it obviously has no effect. So really, there's no escaping dealing with the actual bias point and the point that is made. Now, I'm going to sit down, Justices, but please allow me just to say this in relation to the Kalata group. That yes, there's nobody more than President Zuma, and I presume the other applicants as well, who would like this matter to be resolved. These are people who are freedom fighters themselves. And these are people who want the outcome to be as clear and pure as it should be. Very few people, anybody who has any sense of what has happened in this country would say otherwise. I might be the only person in this room who attended the funeral of Matthew Koniwe, Kalata, Mhlauli, and Mkonto. And anybody who knows the level...
You were still very young.
Pardon?
You were still very young.
I was, but I was at the university. It was in July 1985. And the state of emergency was declared on that day, and we were arrested without trial by P.W. Botha. But that's another story. But anyone who even remotely had any sense of the amount of atrocity involved in those evil deeds cannot, even for any selfish reasons, want to stop a process that goes to dig into that process. The AfriForum was here I suppose they represent those people. Maybe they would want to delay it, but certainly not President Zuma, because these were his comrades. And the issue about going to the bottom of this issue must be done, but it must be done in a commission that is with integrity, that is beyond reproach, and that is neutral, and able to give South Africa the answers that it needs in relation to those atrocities. Thank you very much. I'm indebted for the extra time.
Thank you, Mr. Mpofu. Ma'am, I didn't get your name.
Sokela.
Thank you, Chair. It's Punzile Sokela.
Sokela, yes, Ms. Sokela.
Chair, I will, and Commissioners, I'll be very brief. Mine is just to seek to clarify an issue that my learned colleague, Advocate Soni, had raised in his submissions, and my colleague, because of time, didn't deal with it. And it relates to, it is on. It relates to the issue of the consent ruling. The consent ruling that was done on the 27th of November, and it was in relation to the Kalata Group's request for the leading of evidence. I hope I understood correctly what Advocate Soni said in relation to that. My summary of it is this. It is that the complaint about how the evidence would be handled, the Kalata evidence, or the leading of the evidence, had been settled in the ruling. So the matter is done and there's no controversy about that, and we are in effect seeking to rehash a settled issue. I just wanted to correct what it is that the ruling consented for. And I will invite the commissioners to go to the Kalata Group's answering affidavit, to our founding affidavit. It is at page 20, paragraph 86. And there they quote the ruling in full. In paragraph 2 of that ruling, it is said that after having heard the parties, the Commission makes the following ruling. 2, there is currently a request by the Kalata Group to lead the following witnesses, and then it lists those witnesses. Paragraph 3 of that ruling says that the reasons for the Kalata Group's request to lead the witnesses are set out in their submissions. And then paragraph 4 says that the substantive objections of other parties to the request are set out in their submissions. And then it goes on to deal with how future asks will be dealt with. The Kalata Group explains it the same way in their answering papers. They say in paragraph 87, after that ruling, the Commission adjourned to consider 1, the Kalata Group's request as set out in their submissions, and then 2, to consider the substantive objections of the parties. Now, we have dealt with this to seek to clarify in our answering affidavit to Mr. Semenya's answering affidavit, in our reply, pardon me. And it is at page 37, paragraph 121, where we, in essence, explain or confirm what it is that the Kalata Group's understanding is about what the consent order does. And we say that the agreed upon order was not to settle the issues, but to allow the chairperson to consider the request made to her for the first time and the objections raised by the parties. So I hope it is now clear that to the extent that there is a consent ruling, it wasn't to seek to settle the dispute about the leading of witnesses. That was an issue still for the Commission to determine. I hope that that's now clear.
Yes. Thank you, Ms. Sokela.
Thank you, Chair. Thank you so much for the time.
Well, I thank the parties for their argument in this matter. The ruling is reserved, and we are adjourned for the day.